which has been mentioned the 10th November 2024, for which the matter have not been listed to the ownerships.
Just check it up. Yeah, but I don't think it. I want to make a small mention, my lord. On instruction of Miss Liability, my lord. Item number 88 in today's note. My lord, so far as the instruction that it has been sent to mediation, and the next date it is on.
Mediation going on.
It is going on 4th December.
Meeting mediation report adjourned. Yes.
Yes, my lord. Item 78, my lord.
May I be pardon?
When the mediation is fixed, 4th of December, my lord.
Second. Give it after that.
After that,
Yes.
item, my lord, interim order would be there.
Obviously continue. Yes.
That item number 79, Your Lordship. I have taken the concern of both the parties. And matter may be adjourned to next week, any date.
Interim order is that
Your Lordship, it's there. It's there, Your Lordship.
79.
Your Lordship.
79. Okay. 79. 17 matters, sir.
Your Lordship, it's 2017. So it's a small adjournment I need to take. My learned senior, Mr. Bugapachananda, is having some difficulties today for personal difficulty. Let it be taken up next week, any date, Your Lordship.
See, next week it is very easy for you to tell, but we are not able to adjust our board. That is the problem. And
That's the last chance.
anyway, personal difficulty, but short data. All wherever there is a stay order, short date.
Your Lordship.
Short date.
Item 78, my lord.
1 minute.
Item 78, my lord. The other side's affidavit the husband has made an accident in 2018. Yes. Yesterday he called me and said that her husband has made accident in police. They are now also in police, so could not able to attend today. They need 10 days time to recover. Maybe this matter is about 506 and small officers there. Civil dispute never.
We are going to settle with this.
Already settled. Only we have to file an affidavit. We have to be present in the court and file an affidavit.
Later come in the VC. Need not come to the court.
No, they are very old witnesses and they are in the prison now.
Okay.
They went to prison and it was released it up. 10 days after we are soon. Interim to continue.
This order is only the problem.
No, no,
With the Lord's permission, I am mentioning a case wherein the informant has shown an affidavit before the executive magistrate saying that whatever allegation has been leveled against the petitioner are entirely false due to grudge. He has implicated the petitioner. Now, petitioner is now 70 years old. So after executing the affidavit, the informant furnished the same affidavit before the IO, saying that the police closed the case. But IO, instead of closing the case, harassing me and trying to extort money, I am 70 years old. So I am now.
What are the offenses?
Offenses 304 98A.
304
for D.
na.
304.
Then how can you allege against the police? 304 means serious offense.
Informant is showing that
Informant is the father.
affidavit has been shown before the executive magistrate, not the notary affidavit.
Anyway, give the memos.
Please, kindly, what I request, kindly list tomorrow or
Tomorrow not possible. Give it. I'll adjust. I'll definitely do it.
personal difficulty, your lordship will be tomorrow, day after tomorrow.
I'll just see what can be done. I'll just see.
I may be pardon to mention, my lord.
Obliged, your lordship.
Let me make a mention. I am VCR Puri, my lord.
Give that number to Mr. Jena. Give instruction. What he says is,
Police
executive magistrate, before executive magistrate affidavit is given.
4B is there, my lord.
Just see if possible. Otherwise, no.
Ticket number
Number
I may be pardon to mention, my lord. Item number 10, my lord.
okay.
Item number 10 of my lord, today's board, my lord. I have some personal difficulty. Can it be on next week, my lord? Any day next week, my lord.
Okay.
Or at least tomorrow, my lord, that will also meet the purpose. I am outside, my lord.
Rest matter, I'll take it up according to yes.
Item number, that is, earlier it was before, my lord. Earlier it was there and my lord is also kind enough to pass the order directing that if a prime petition will be filed, that will consider favorable, my lord. That is the order. So tomorrow, my lord, that will meet the purpose, my lord. If not, my lord, next week, tomorrow, I am outside, badly placed. That's why I am making mention before, my lord.
It's all right. Your personal difficulty, I'll adjourn it. No problem. We'll adjourn it. and-
Interim order to continue, my lord. Any day, my lord, to fix, my lord.
Same interim order.
Interim order to continue, my lord.
Yes, yes.
Much obliged. Much obliged.
Yes.
Much obliged.
Question, my lord. Two criminal miscase of 2024 matter. In spite of filing several memo has not been listed, my lord. Can it be taken tomorrow?
What is that matter is about?
My lord, the criminal miscase 3854 of 2024. Another is 2843 of 20.
It's all right. All the matters are coming up civilly. So that might be the reason. Review the memo. We'll see.
Public.
Yes. Yes. Start.
Item number 1. In this matter, the conducting counsel, as we speak, Malad is undergoing a chemotherapy today in Pune. At 11 o'clock, he has a chemotherapy. The conducting counsel is suffering from.
Okay. Simply, Mr. Janna, learned counsel for the Marana, learned counsel for the petitioner, learned counsel on behalf of who is the lawyer?
Mr. Parija.
On behalf of Mr. Forija, learned counsel for the petitioner submits that the counsel is undergoing. But last time you appealed, Mr. Marana.
Yesterday it was listed. Yesterday the matter was listed.
No. 5/3/2024 you appealed.
That was a same appeal, Malad. It was restored. It was not dismissed for non.
Okay. The counsel is undergoing chemotherapy. Has he seeking adjournment? When do you want?
2 weeks after.
After 2 weeks, at least after 2 weeks. Okay.
Item 2.
Item 2, our power will be related matter. Transfer. Transfer.
What is this matter?
376 box in there. And he has FIR nothing has been given. This is the only copy of the
Incomplete petition, huh? Nothing is there.
nothing there.
No, investigation is still going on.
And 2019 matter, the criminal proceeding 376 2 and box is there. But he has not provided anything and nothing has been given. And now the lordship knows that box on the ground that will be settled. Right?
You
Cannot be settled.
you want to withdraw your Tapaswini Sinha on behalf of Tapaswini. Tapaswini Sinha, learned counsel. Patel. Those who have filed this petition seeks to withdraw their Wakalatnama, and the party has taken no objection from them. Next one, non-APS for the petitioner. I have
Para 4.
Para 4.
Compromise counter say the High Court of Orissa.
The petition in the present petition is seeking petitioners or petitioner is seeking quashing of the entire criminal prosecution initiated against him in FIR number as well as for PS case number 61 of 2019 for alleged offenses under section 376 AB 376 2N 294 506 IPC read with section 6 of POCSO Act. The petition is briefed up for any details, and except to the FIR, nothing is filed with the petition. Moreover, in the para 4 of the petition, the petitioner has contended that the parties have settled their dispute. I am not inclined to entertain this petition at this stage, and so the same is dismissed. Yes.
Instruction asking by last 2-3 occasions, your lordship, even prior to a lordship, instruction was sought for. Sorry? Prior to a lordship's last order, your lordship, the other bench also directed for instruction, your lordship.
What is this matter?
So here for last processing of the FIR in a DA case of the year 2020, and last time the lordship asked me the status of the investigation. My lord, I have not obtained that. For last 4 years, the case, the investigation is still going on 4 years. For the last 4 years, your lordship. And I am in a state of. I say the grounds he has asked for. He is saying that I am not getting promotion. He has the other. That is not the only ground. But you do this way because the last promotion cannot happen. Don't argue this, but the fact of remaining 4 years. But say that you can't raise a case and the citizen will keep on running around. In every case, you lost the FR and here the informant is DSP vigilance. In every case, FR will come back and they will rely on information. Yes, sorry.
The petitioner is seeking passing up for the Hon'Ble Vigilance case number 22 of 2020. Registered against him on 13/8/2020. The Learned Counsel for the petitioner contends that since 4 years the investigation is going on as a result of which his career perspective is getting hampered. Mr. Maharana seeks one more adjournment to obtain instruction regarding the status of investigation. And leaves the matter on 30th. Instruction PDC for obtaining instruction.
Just one thing, the lordship keeping it, it's all right. It's not the first affair. It's an outcome of the affair which was earlier lost. I understand what is exactly happening. Thereafter, I will go into the merits. They'll have to go, but he has to tell me whether investigation is over or not. Let it 3-4 cases. Right, what will you? Yes.
Item 4. This petition, the accused persons are before the court with the prayer to annexure 1, directing splitting of the case against a government employee. Your lordship can see the order dated 10/5/2023. 10/5/2023, the last order. Inadvertently, this stay could not be extended, though it was earlier extended. That is why I made a mention, and 2 weeks back it has come today.
Hey, you are agreed by what?
The annexure 1, directing splitting of the case. But here, the charge sheet has been filed that I took some more money by converting the agricultural land to Gharbari land. It is on the national highway. I have got huge land, and only the cover portion of the national highway absolutely having no case. The due process of law, it was converted. The land acquisition officer is also an accused. He filed the bail, got the bail. And the state is saying that they are not able to know whereabouts, and could not produce before the court, for which the court has
Whereabout of the
land acquisition officer.
therefore the trial is
Split it. And I am against the order of splitting because he is the accused who has done the all conversion in my favor in the process of law. And in his absence, the trial will be, I will be prejudiced. And there is no, the state will say that his wherever is not known, unthinkable. A state will say that wherever is not known. Evidence not executed. In our
how are you agreed?
I am co-accused. Why should it be splitted? Because his presence is necessary if joint trial.
If one of the accused is not agreeing it by XYZ reason,
If not,
and the trial has to give to make it expedite.
but that is the case. The government servant, suppose to with all respect, madam, in our earlier age, we are giving example to.
I understand it, but see, it will endure to your benefit.
No. It will cause little prejudice, madam.
What prejudice?
Well, here the accused, he has done the conversion. I have filed the another connected matter before your lordship, item number 77. I have filed the petition to.
What is happening to the What is happening to the NBW? Why are you not
not able to do.
NBW issued against your former officer?
I am coming to that.
Yes.
The same petitioners have filed quashing of the two.
I'm not on that. Forget about everything. An NBW issued against your own officer.
That is why have you not executed that? That is not executed. Despite repeated effort and 82-83 process,
He is not, whereabout is not known from last 10 years. Is Master taking pension? No. Everything has been stopped. Not, he has never applied also. He has never joined in the post also. The mother, the wife expert gala sitra bishay asi nahi. The sister, the daughter, the jio vagara asi nahi. Lordship kindly see the instruction.
You have to file by way of memo with the copy to me.
And another aspect is he has filed a petition for quashing of the proceeding. That is pending there. He has filed another petition for challenging discharge, rejection of order of discharge. That is also pending. And now he is challenging the splitting up.
The discharge.
Multifarious proceeding and a reinvestigation, further investigation, number of proceedings, petitions are filed here by the same petitioner.
I should not file it. Is there a constitutional?
It's my duty to bring it to the notice of the Honorable Court. You have not brought it to the notice of the Honorable Court. Without making any submission. Three seventeen two CRPC clearly says so. It can be split up. Now, I am only interested to know what step you have taken. That is LBW is executed. Everything is all set up. 10 years nahanti.
I guess Morichi Mochichi, it is state guard, a state government, the citizen of the state, and he was employee of the state. If he is dead,
तारा employer को उनसे join करेंगे.
what did you tell?
Declare.
State would have
So that all also can right. Proceeding will be stalled. Yes. Yes. And you also kindly see provision 317(2). That I know. That cannot be. What is the illegality in the order? Yes, sir.
That's a total inefficiency of the state.
That's right, but they have taken all
As your lordship statement. The whole point is if the state, if your lordship condone this, the inefficiency of the state.
No, I'm not condone. I will pass the appropriate order.
Here the whole point is that I was going to make a mention that the 77 is connected matter. He is starting in the very high court. They said that I am not mentioning the other matters.
77 for question proceeding.
Lord, as it was necessary.
Well, I will hear that matter. I will dispose of this, sir. I will dispose of it. I will dispose of it. Give it to me. I will give the case in a 12.
Give this. And 77 you also will see. I have to go on. Then all copies are there, no response has been filed.
We'll see that.
I was going to mention it, and he is telling, after he is telling that I am not mentioning about
8283 proceeding has already been initiated. That I will declare him proclaim offender. It is in May 2024. It must have been initiated by now. Well, just telephone him and call and tell him.
the order itself says that it is initiated. Your lordship is asking the next question.
The thing is the order of the it is the duty for the prosecution to that is to be you have taken steps, sir. But the same time the order is different order is concerned. What is the illegality? There is no illegality. So next. Yes.
If necessary, that 77 may kindly pass over.
Yes.
If necessary, I am here, but
I'll take it up after lunch. Don't worry. You attend your work. Yes.
Item 5, 6, and pass over.
Pass over. 5 and 6 both. Pass over.
Item 7.
Item 5. Lunchtime.
Petitioners are father and son, my lord. One is the father, two is the son. Entire family member have been implicated in a village politics.
Opposite party number 2 is?
2 will have been the informant.
Are you related? No.
No. He is one of the villagers. He is the informant. She lodged a complaint alleging that due to death of 2 hens in the village, a meeting was going on. And the meeting was presided by this petitioner 1. All of a sudden, there was some altercation between 2 groups. And son of petitioner 1 came with a bat and assaulted to the deceased. As a result, he died. So charge was framed under section 147, 148.
Yes, I've seen it.
But it is not a case under 302, Miller. So far as these petitioners are concerned, they are neither the assailant, they are only present and attending the meeting. The meeting was called in a village. Due to political liability, the entire criminal member have been implicated, that too in a case of 302. My only concern, Lord, it cannot be a case of 302, and my session judge has really realized that, and the order itself speaks. Without getting the prima facie case, he has proceeded with the trial.
Yes, so,
The Lordship can return to page 39.
yes, I'm there.
The two judgment has been realized.
Page 30, come to page 30. During the course of investigation.
During course of investigation, I examined the witnesses, recorded the statement, displayed the fact.
Court member, he is wearing apparels along with so
Right.
so.
Who is the equal of offense? No, it would be that.
Also postmortem,
FIR 161 statement, no Hon'Ble I have been implicated. Seven accepted.
164 statement.
No, my lord, first time. Once is what that 38 page 38 your assessment kindly see.
What are the materials against these people? You tell me just. 161 statement. Let's see.
Last it submitted under section 149
Yes.
and the government trial court has
No, he is agreed by 302.
302. My lord.
302.
But once 149 is there.
149.
No, entire bill of
34 must be there. 34 is not there.
No, 34 is not there. Why didn't only one seat applying 139? They cannot implicate the entire member who are attending the meeting. Only because my son has assaulted.
Let us see what are the exactly what are the materials you tell me.
Absolutely not. Only allegation I was there.
Come to
The allegation that you last can turn to.
come to the
Page 38.
Yes.
During course of investigation, after submission of charge sheet, cognizance was taken. Because cognizance was taken.
What is your name?
My name is Bijan Bera, Brahman Bera, and Bijan. Brahman Bera and Bikan Bera.
But the FIR ballot disclosure law has been participated.
No, no.
Page 13 was.
FIR, then why 227, why the cognizance? Then that should be directly trial on the basis of the FIR.
Time of trial.
So what is the investigation? What is the material against me? That is important.
Law is at the time of the charge ballot only to consider whether prima facie case is on presumption whether prima facie case is better.
Yes, prime is I am saying there is no prime is to constitute an offence under 302. At best, in the case of 304. At any stage, it can be altered.
164 statement.
Again.
Please, yeah? Give me. Issue notice. 1 week after. Get me to 161 164 statement. I don't think you would have a case.
Milord, I can justify your lordship absolutely no implication in so far as these two petitions are
Let's see,
concerned.
149 is there. It is a congregation.
Milord, 149.
And how will I 482 petition? I will.
Appreciate, Milord, kindly. There are suppose 500 persons attended the meeting. Can they be all implicated on the 149? There must be a meeting of mind. There must have some.
Deciding 482. I know.
There must be material to constitute that offence. Not that all 500 will be.
What have you find? 164 is not there. And there the charge sheet itself was that many evidences were collected. It's connected. I don't know.
The land
I can't dissect the charge sheet with you. And
no, I should have come up with the undersection. That is there, Milord. Like I'll show in the next one. If my land friend will not bring it. I don't think you have filed since long, Milord. I pray only a short adjournment be granted to state as well as to me.
I simply urge it to file additional document, both of you, and the state council to submit the 164 statement of the witnesses recorded.
You are absolutely.
That 164 statement itself would be
Yes, enough. Yes, Milord.
Yes.
Only the liberty, if I make an application for adjournment.
No. You had not done. You are asking for quashing.
That's why it is not.
Same time somebody has died. I can't pass an interim order.
You will also fix it. I might have if I my photo
After a week.
anything. No problem.
The charge sheet has already been filed. Entire charge sheet copy is given to you.
That's why, Milord,
Given to you.
Act prescribes that, Milord. On 227, merely because the charge sheet is filed, court will proceed to.
It is also prescribed that once a charge sheet is filed, the entire copy is given to you.
Yes, I'm giving you.
You are filing a case in High Court
Yes.
without those documents which are there with you.
Annex 2 is my charge sheet. Whatever the copy I've been supplied, I've given. Not 160, but it's part of the charge sheet. I'll arrange that, my lord. I'll do it. I don't want to suppress anything.
Man, I suppress, but you have to, I'll at least educate documents so that I can read it and understand what it is. Only charge sheet, one page of charge sheet, and you say that declare me innocent.
No more. I'm saying it is a case of 304, not 302.
Maybe. Now if 227 is rejected, shall I allow you to argue on this point at the time of review of charges?
There must be a prime office. That is the law. And sessions
304 is not 302 if you are saying that you argue at the stage of framing of charges.
yes, that
I'll give that.
that stage, the trial is going on, my lord. At that stage only.
Charge is already been framed.
Yes, trial has come in.
No, your application is rejected. Charge is not even framed.
No, your lordship, my application is 227.
227 is rejected. Thereafter, charge has been framed or not? I'm asking.
At the time of framing charge, we used to file application on 227.
But charge order is something different. Your application is
I'm not challenging charge order. I'm challenging only the.
that's the another problem. I'm not hardened you up. We'll see. Get this good. Yes.
I am bit busy, my lord. In view of order dated 24/1/2024, the complaint will be examined on 2/12/2024. So I pray only if it will adjourn to after 2, then it will be convenience to adjudicate the case. But that is the reason.
Sorry, I didn't follow you. Sorry, what do you want?
I am challenging the. It is a 138 matter. I am challenging the signature of the draft, my lord. That's why I filed to send the expert opinion for the testifying the expert. That has been rejected. But on 24/1/2024, this Honorable Court opined that after examination of the complainant, it will be properly adjudicated. In view of that, the complaint will be examined on 2/12/2024. So it may be taken up after.
Have you issued the check? Your signature is there?
No, signature is disputed, my lord. But that has been not sent to further export, my lord.
Show me your reply to the 138 notice. Show me your reply.
That is page 13, my lord.
Page 13? Okay.
Check, my lord.
No, the notice issued to you under section 138 NI. Have you replied? Have you replied or not? Where is that?
Yes. In my petition also, I have stated that that is annexed to page 12, my lord.
Yes.
That the accused never issued the check in favor of the complainant and he has not signed over the check, my lord. On that score, this Honorable Court has granted after examination of the
I am asking another question. The notice which was issued to you under section, the statutory notice under 138 NIA, have you replied to the notice?
Yes, I have agreed, but that has not annexed, my lord. But my petition and objection has been annexed, my lord. On the objection, I have heard that is the reason on 24/1/2004, this Honorable Court opined that by this law are required to be gone through to consider legality of the input order annexed 1 after examination of the complainant. But that is the reason, my lord. So no urgency input and deposition of complainant as well as the other witnesses. So complaint will be examined on 2/12, my lord. For that reason.
See this. See the service position. Opposite party. Huh? Acha. Issue notice to opposite party number 2. Within 2 weeks. Solo. Yes. Solo. Yes. Next.
Item 9, may I please, Your Lordship. Your Lordship, this is the matter in which the principal accused person has been died and the petitioner is the present wife, my lord, of the deceased principal accused person, my lord. But on the last occasion, my learned senior counsel for state
But in the last occasion, I have recorded your name, that you will argue the matter.
Yes.
But we were repeatedly taking time, not because we didn't have a case, or not with great judgment, but because we're not having the 161 sequence. With a lot of difficulty, we managed to get the 161 sequence. Let my learned friend place the matter, because since your lordship had indicated that he is supposed to argue the matter, let him place the matter.
He argues very well.
Yes, sir. If assistance is required, then.
If assistance required, you can. Yes, tell me.
Lord, I kindly see the order, the judgment which was relied by my learned senior.
What are you asking, by the way? In
My lord, the case which was relied by my learned senior counsel, my lord.
Quashing of the entire.
Yes, my lord.
Yes.
My lord, the principal accused person has been died. I have been implicated under section 107, 109 of IPC, my lord, for abatement, my lord. My lord, I am relying on your lordship. My lord, this judgment is, the facts are different altogether, my lord. In this case, my lord, wife was not involved, my lord. And my read the relevant para, my lord, paragraph 4 of the judgment, my lord. But in this case, certain monies have been transferred for and diverted for the family business of the accused persons, my lord. Yes, my lord. But may I read the relevant portion?
Yes, yes.
My lord, the petitioner have been charged cited under section 13(1)(e), 13(2) of PC Act and section 120.
That the abatement of principal accused and was the public servant and was in position of assets.
Was public servant and was found in possession of asset of disproportionate was from sources of income, which was further diverted to run their family businesses. My lord, in this case, my lord, there are certain properties in my name. My lord, I am relying on your lordship's judgment, my lord.
What had happened in this matter ultimately?
In this case, my lord, the CLMs have been dismissed. On the ground that only merely the principal accused person has been died is not amounting to discharge the accused persons from abatement. My lord. Yes, my lord, I am relying on your lordship's judgment, my lord. But in CLMC number 2, the
abatement is an independent offense.
Yes, my lord.
Even the principal accused goes, the abatement doesn't vanish.
Yes, my lord. My lord, may
I also tried and established.
Yes, my lord.
Whether you abated the principal accused or not.
Yes, my lord.
Though the principal accused has died.
Yes,
yes.
My lord, I am relying on your lordship's judgment, my lord. My lord, may kindly see the relevant paragraph. Well, paragraph 5 of the judgment.
Yes.
My lord, the present case is squarely covered by your lordship's judgment, and my lord, your lordship has rightly held. My lord, may I read the relevant portion, my lord? Paragraph 5, last 4 lines. Read it. Yeah, my lord. In the absence of any defense put forth by her, by justifying the assets acquired by her, and on her face of a plain and simple statement that the properties are purchased by her husband in the name per se, will not attract the offense of the abatement. This is contemplated under section 107.
This is the ratio legal.
Yes, yes. My lord, in this case, my lord, may kindly see the 161 statements, my lord.
Yes.
The wife and the husband.
Give a copy to him. Give a copy to him.
Yes.
Yes.
My lord, I'm extremely sorry, my lord. Yesterday night I have procured, so I cannot photocopy that. I have
photocopy. What is you do?
My lord, to serve on.
Get a photocopy and give it to him, and I'll pass it over. Huh? Give all this. So that you will not seek examination.
Yes, ma'am.
Yes. Give a copy.
It's my
yes. Yes, pass over.
Maybe.
Yes.
And proceeding is under challenge.
Yes.
Where some of the co-accused persons, they have approached the Honorable Court seeking quashing, and after hearing the proceeding was quashed in respect of them. I have annexed the order dated 6/4/2023 under annexure 3.
Who are the Jeevan Jyoti Mahanti?
The one of the accused person.
What melody?
Round of question.
Here it is alleged that during college election, some of the students of the college, they were demanding suspension of the principal.
Okay.
And also raised slogan against the health minister, the then health minister.
What are the offences?
Offenses, my lord, cognizance was taken under section 143, 353, 341, 294.
And the accused persons against whom the quashing has been allowed. They are also the students.
Students, they have been named in the FIR. I am also named in the FIR.
Yes. Then I'll quash it. I'll quash it. Okay. Quash it. Right now. How many petitioners?
There is the three petitioners.
Sir, the petitioners are accused in the FIR number shown. Allegation against the petitioner is shown. How many petitioners were there in that CRLMC?
Five, my lord.
5 petitioners. 5 other co-accused petitioners, those who have been named in the FIR, had approached this court by filing CRLMC number 491 of 2022, seeking quashing of the entire criminal prosecution against them. The coordinate bench of this court dealt with the matter in detail and passed the following order. Para page 19, para 6, 7, 8, 6, 7, 8. The counsel for the petitioners submits that the role assigned to the present petitioners are verbatim same to that of the role assigned to the petitioners in CRLMC 491 of 2022. Therefore, their case is strictly covered by the judgment of judgment of this court dated 6/4/2023. Mr. Mahanti, learned counsel for the state fairly submits that the judgment of this court dated 6/4/2023 in CRLMC number 491 of 2022 has attained finality, as the same has not been challenged by the state. Hence, the petition deserves merit. In my considered view, the case of the petitioners are directly covered by the judgment of this court in given duty Mahanti Supra. Accordingly, relying upon the state judgment and the facts of the case, I'm inclined to allow this petition. Accordingly, so and so is quashed. Yes.
Item 12.
Yes, sir.
When arises out of a 138 proceeding under the negotiable instrument.
Yes. You are the accused?
I am the accused.
Yes.
The complainant is my brother-in-law. And the wife's advice,
Then it is more of a reason that you should settle.
वो वाइफ कहना कि ताकू दवा टंका से ना ये लड़की will find आया
Check amount?
चेक अमाउंट कितने 12,000 ना कितना मतलब ये लड़की will kindly see the bank account was closed in April. सवाल हो गया तो केस करा negotiable instrument act है ସେଥିରେ ୱିଟନେସ୍ ପଡିଲା ଯେ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟଟା ସିଲ୍ ଦେଇକି ତାପରେ ଫେର ଜୁନରେ ସୟା ଗୋଟେ ଚେକ୍ ପ୍ରେଜେଣ୍ଟ କଲା ଯେ ମତେ ଗୋଟେ ଚେକ୍ ଏପ୍ରିଲ ମାସରେ ଦେଇଥିଲା ସେଇଟା
Petitioner is accused in ICC case number 132 of 2023. Initiated by opposite party number 2 under section 138 NI Act on the allegation of dishonor of the check by the bankers of the petitioner, check amounting to 8 lakhs. dishonor of the check amounting to 8 lakhs by the bankers of the petitioner, by the bankers of petitioner.
On the ground that the bank account has
On the ground that the account has been closed. Account has been inverted account has been closed. Mr. Mahanti, learned counsel for the senior counsel appearing for the petitioner, submits that the petitioner and opposite party number 2 are related. The petitioner number 2, the opposite party is the sister-in-law. Brother-in-law. Brother-in-law of the complainant is the brother-in-law of the accused petitioner. Issue notice to the opposite party, since the dispute is arising out of alleged dishonor of check, and the parties are related. I feel it appropriate to
another criminal case has also been instituted against him on my
and there are cross cases against we filed by the petitioner against the opposite party. I am of the considered view that the matter should be referred to High Court Mediation Center. Baleshwar District Court Mediation Center, I am saying. District Court Mediation Center to explore the possibility of settlement between the parties. And I will issue notice stay and I'm sending both everything at a time I'm doing. The High Mediation District Court Mediation Center, coordinator of District Court Mediation Center shall issue notice to the opposite party fixing a date for exploring the possibility of a settlement. Awaiting the mediation report, leaves the matter on certain day. Meanwhile, the proceeding in ICC case number so and so is stayed. Yes. All the things should go together. I mean, something may happen.
So, to the complainant, let the notice go so that he
notice. I will issue notice. Also. Issue notice.
Yes. Item number 13, may I please, my lords. Lords, cognizance order dated 18/7/2024 is under challenge, my lord, which is at running page number 1850. 13, my lord. 13, no. Okay. Running page number 50. Cognizance order dated 18/7/2024.
Yes.
Where the cognizance cognizance has been taken of offences under section 224 and 223. My lord, so far as the present petitioner is concerned, my lord, he is a public servant and was serving as a jail warden, my lord.
Jail warden?
Yes, my lord.
What are the allegations that he charged it?
So far as allegations are concerned, one UTP has escaped and while he was on the duty, my lord. So, my lord, my ground for at this stage, my lord, 197 has not been complied with. And my lord may have a glance to the first order. Dated 28/8/2024.
Yes.
Sanction was not at all.
The outset submit order of that no sanction of part of yes.
Yes, my lord, and
but contention of the
sanction 197 sanction.
Not the fact of the case also kindly so the fact of the case also.
Yes.
As per the duty charge, the petitioner was deployed in the inner gate, your lordship. As a warder, was deployed in the inner gate on the very fateful day, your lordship. On the very fateful day, in the gate number 1, who was a lady was deployed for the very fateful day due to some health related issues. By oral permission, his authority is left to the office and go to her residential also. And oral direction, the present petitioner was allotted to gate number 1. At that point of time, and the present petitioner directed to the convicted person also in the UTP to throw away the garbage out of the gate, your lordship. In the first gate of the outside of the gate, your lordship. The present petitioner directed to the UTB
to throw away the garbage on the, by showing from the jail
Whatever,
to
yes.
the outside.
Yes.
At that time,
He went and went
Yes,
away.
Lordship. My respectful submission, Lordship.
Ah.
The present petitioner at that point of time, his dereliction of duty, he was not discharging a public servant, Your Lordship, because he was directed to deploy in a particular place. But without doing so, without prior written permission, he is left to have the need for his deployment and deploy another place, and for which the present UTP is able to escape from the jail custody, Lordship. Therefore, 197 immunity is not affected the present petition, Lordship. That is on
Come to 223.
here. I'm coming.
Come to 223.
Up.
223 IPC.
Yes, yes, yes.
Read it.
Yes, sir.
Read the definition first.
Yes, sir. Escape from confinement or custody negligent suffered by a public servant, Lordship.
Then,
Yes, sir.
I'm negligent by public servant. That's your charge.
But
If he is a public servant, you admit. Negligent, you admit. That is your charge. Then 197 is mandatory. Simple. And further argument is not required.
Squarely covered by Nucleus.
Further argument is not required.
my respectful submission, Lordship, on the very fateful day, without prior.
Whatever. You have charged 323 and 324. Then 197 is mandatory.
But
Simple. Why are you arguing on facts? Come to the law.
Squarely covered by
Judgment.
yes, I have gone through, Lordship.
Judgment.
There are two decisions rendered by this honorable court and relying the best one. No, this was with regard to that sanction, Manoj.
That's right, but 223, 224.
224 not there, Manoj, but it says that sanction is required for proceeding on one sanction. And another judgment by dead bench also and rely. Set the dates for that.
Yes. You talk to 222 and 223 and 224.
223, 224, Manoj.
Give any judgment if you have. Why are you bringing so many?
With regard to that ratio, Manoj, I've cited the
Ratio, I know, that's my judgment.
Manoj.
But you talk about see the charges are 224, 220, 223 and 224. Yes.
Your option
This can only be done by the public servant. Nobody else.
Manoj.
If public servant, then 197, simple.
Manoj may come to running page number 43, Manoj.
What do you want to show?
Manoj, he was not even developed. I'm not going into the merits, Manoj. That 197.
Would you like to say anything?
Yes, Lord. I'm not condemning the way, Lordship, but facts remain on the very fateful day, he is not discharging as per the direction.
But why? See, I'll set aside you get sanction and proceed. That will not preclude you to proceed in accordance with law. I'll set aside it.
For the petitioner, Manoj, because
How many?
only one petitioner, Manoj, the public servant, because in that case, Manoj, one accused is there, Manoj, for this has to be.
Who is that judgment you have shown me right now? The other judgment right now. Petitioner is accused in the FIR number shown. So one of the accused in the FIR number. He was posted as.
He was posted as jail board.
Jail warden, Manoj.
He was posted as a jail warden on the date of incident. The allegation in the prosecution case against the petitioner is that where have you written that prosecution case? Para 3. Para 3 in the petition. Okay, para 3 in the petition. After investigation, the charge sheet has been filed
On
against how many accused?
Manoj, one accused and the present petitioner, interestingly, Manoj, the charge sheet.
How many accused charge sheet is filed? Why are you?
One accused and Manoj, the present petitioner.
One accused and another gentleman.
Yes, sir.
How many accused I'm asking?
Manoj, two.
Only two.
Two. Simply said two accused. Two accused. On 21, 6. Charge sheet is filed on 21.
29 6 my lord.
29 or 21?
29. 29.
2024 against the present petitioner and another co-accused person. The present petitioner is the admittedly a government servant. The charges level against the petitioner is for alleged offence under section 224 oblique 223 and 34 like this. The code below wide impugn order dated 26/10/2022. Cognizance is taken on 29/5/2024.
No, no, cognizance 18/7 na? 18/7. Cognizance is 18/7/2024.
18/7
2024.
18/7/2024. The JMFC Dasarla has taken cognizance of offences punishable under section 224 oblique 223 oblique 34 IPC.
34 is not there.
34 is also there. No, 34 is not there.
34 is not there. And charge sheet also, my lord?
224 and 223 IPC. IPC. IPC against the petitioner and the co-accused person. The petitioner is agreed by the same. Mr. Mahapatra and counsel for the petitioner submits that for offences punishable under section 323 and 324 for which the cognizance has been taken, it is the sanction under 197 CRPC was mandatory. Before mandatory, in the absence of the sanction required under law, the cognizance order is best. The offences under section 323 and 223 and 224 reads as under Mr. Mahapatra, letter counsel for the petitioner, also relies upon the judgment of this court reported in 2024, Roman 2 ILR Cutter 1073. Nirupama Sahu versus State of Orissa. Judgment reported in 2022 live law Orissa 154. That is Ajay Kumar Barik versus State of Orissa.
Orissa and another.
Orissa and another. Relying upon the aforementioned two judgment, the Mr. Mahapatra submits that it is mandated under law that for a public servant to prosecute a public servant and taking cognizance of offence sanction under 197 CRPC is mandatory. It's mandatory. Mr. Marty, the state submits on facts that a case is made out against the petitioner. Not as a case it is made against president on the basis of evidence collected by the prosecution. I have produced the charge sheet and related documents filed by the prosecution, which form part of the charge sheet. Although prima facie case is made out against the petitioner from the alleged from the material placed on record by the police in the charge sheet. However, in the absence of sanction under section 197 CRPC, the court ought not to have taken cognizance of offences punishable under section 223 of oblique 224 IPC. Hence, the cognizance, the impugn cognizance order dated 25/10.
Cognizance order dated 18/7.
18/7. So it's bad in law. Hence, the same is set aside. However, however, setting aside the cognizance order at this stage will not preclude the prosecution to proceed in the matter in accordance with the.
My lord, may I submit to that extent, my lord? My lord, so far as prima facie is concerned, my lord, your lordship may just observe two things because, my lord, that will trouble me, my lord.
Prima facie, I am convinced that.
My lord, may I just observe one page, my lord, if after that your lord.
What do you want?
Page number, running page number 43.
43. Yes.
My lord, in that, this is the register which they maintain, my lord. My lord, on gate duty, the present petitioner was not been deployed. My lord, I will ask to the first person, Srimati Pasmita Sethi, my lord. She was in the main gate charge, my lord. And the present petitioner, after that, my lord, serial number 2, he was deployed in the kitchen and other places, my lord. And my lord, these are critical dispute, my lord.
And I am saying, my lord, that same thing also. He was deployed as gate number 2. But his illness,
I'll satisfy the in order that you should be happy that. Yes.
Next, that observation will affect.
14.
Yes, that's your mother.
My lord, I'm appearing from Dhenkanal through VC, my lord.
Yes, sir.
This is an application under section 528 of the BNSS new, which is 482 old, Your Honor. My lordship, this is a quashing.
Yes.
Question of the order at page 25, my lord, running page.
29. Okay.
25, my lord. Now, the order arises out of an application filed by the complainant. I am for the complainant, my lord. In the case of 138, my lord, I was facing a trial for having given a check of 158,593, which was original. And during course of the evidence, my lord, the complainant admitted. I am for the accused, my lord. The complainant admitted that the liability of the accused is only 58,000, not 1,58,000.
When is that?
That is that, my lord, the evidence part page. My lord, running page 17, 18, my lord. Page 18.
Yes.
Para 16. Para 16. Page 18. Prosecution para 16, my lord.
Whose page you are talking about? Yes. 18. Okay.
My
Okay.
lord, the liability mentioned in the check is the liability towards as a distributor. Para 17. It is a fact that after joining as a distributor on dated 17/9/17, he has paid the sum of rupees 1 lakh as a security deposit. Then para 18, my lord, it is a fact that money paid by the accused as security deposit is still with the firm. Then 19 para, the current liability upon the accused is now only 58,593. That being so, my lord, I had applied on under 56 of the NI Act for and along with the judgment of the Hon'Ble, I have apex.
You are also agreeing this fact that the liability is only 58,593.
My admission is 8,000, my lord. Because subsequent, this is the second, the para 20, it is not.
Your case is that the liability is only 58,000. So
8,000.
So you can't prosecute me and for the 138 NI. For the take up 1 lakh rupees.
Yes, my lord. So that in which I had that.
I need to notice you deposited that amount. 58.
No, sir, not 50, 8,000, my lord.
That is your case, so what to do?
So para 20. My lord, para 20 may kindly.
Yes.
Paid another 50,000 rupees, my lord. Through bank. But that due to that sunny storm going on, it could not be recorded there in their office. That amount is also paid by me. So I have already.
You deposited 50,000. You deposited 50,000.
My lord, 8,000.
No. That money is not paid. That I will not go into all this thing. It's 138 matter on the basis of some admission. You had to move an application before trial court.
Yes, my lord. That is that.
Where is that application?
That application rejected, sir. Para 20 euro. My lord,
para 20 you have asked. It is not a fact that on 3/5/2029 the accused has paid 50,000 rupees. He is denying it.
I denied it. But this fact is that I have paid 50,000. My
liability. Then that will be decided in the final stage.
Yes, my lord, I admit the liability to the extent of 8,000, my lord.
No. See the check. Why are we issued the check then?
As a distributor, the master check, they had taken the admit also that. They admitted that at the time of the agreement as a distributor, he had
No. You had issued a check of 1,58,000.
No, never. I never issued a check of 1,58,000. It was a blank check given by me as a master check at the time of agreement entering.
You had signed the check.
Yes.
Blank you had given.
Yes, yes,
That's right. But where is your reply to the 138 notice? You said that I have given blank check. What is that?
Sir, as I did not send a notice, I filed the case. That is fine, my lordship. But admitted fact is that for a liability of 58,000, can I face a trial on one?
No, I'll not disburse that money to the complainant, but you have to deposit.
I may be appreciated only to one extent. Now, the Supreme Court and the other high courts have held that for the liability of a less amount, a higher amount of check cannot be determined and a case cannot be filed. That is my contention, my lord. This is in conformity with the lordship's view taken in that Dasawadi Timbakabhai Patel versus Hitesh Mahendrabhai Patel, 22nd to 2022, my lord. In that, the learned apex court has held that for the amount which is
reply to the statutory notice done.
My lord.
When presumption opens you will go the trial and this rebuttable presumption you have to close the trial and face do it.
I have discharged it during course of evidence. I have brought it from the mouth of the complainant that liability is not 1,58,000. So how can I face a trial?
At the same time, you have put a very specific question that liability is only 58,000.
He says.
And then the next question is, I have paid 50,000. He doubts that. So then I can't appreciate the evidence at this stage. Every line I can't read and let it go. I am ready to examine it, subject to you paying 50,000 rupees. I will issue notice.
50,000.
Don't find it out in the trial court. Who stops you?
My contention before this lordship is with regard to a petition which I have filed in conformity with section 56 of the NI Act. That may kindly be taken care of by this honorable court. That 56 says if I have paid any amount towards the liability of the check amount, then that has to be endorsed. That has not been done. I challenge the order of the Honorable JMFC Bhubaneswar in that regard only. I don't say that my liability is this or that.
Yes.
The 56, my lord.
Just read 56.
Beg your pardon.
Read 56.
Sir, 56, section 56 of NI Act. My lord. It's an endorsement. That means the amount which
The application is 56. Therefore, you have to pay 50,000 rupees. I know, subject to petitioner depositing 50,000 rupees before this court, issue notice to opposite party number to opposite party. Yeah. Let me within 3 weeks.
Yes, my lord. The time and a stay application I have filed also.
Yes, I'll say it subject to it. Subject to yes, the proceeding before the court below in ICC case number 554 of 2023, pending in the court of JMFC, Province to Bhubaneswar, Khurda, is stayed till further orders, subject to petitioner making the deposit as stated about. Yes.
My lord, before this honorable court, I'll deposit, make the deposit.
50,000 deposit before trial court. Yeah, before trial court. Before trial court. Yes.
Subject to my liability ultimately held. Or my liability.
This is always without prejudice.
Obliged.
Without prejudice. Yes.
Obliged.
Yes. 50. Well, it came from brainstorming that the petitioners have been brother-in-law, father-in-law, and mother-in-law. The case was instituted on the basis of a complaint petition. 419, 420, 424, 420. Brother-in-law, father-in-law, brother-in-law, mother-in-law, and father-in-law. Son-in-law less than filed a complaint case. Who is the complainant? Complainant is the son-in-law. Why are you not made in party? No, here I have the, only person who clustered of the NBW, that is a millet. I cancel the NBW, no problem, but you go and appear and do whatever. Millet split. Case is that millet. I got millet, we got anticipatory. What do you want? NBW, I am cancelling. Whatever you want to do. I allow the petition. Yes, right on. Actually, 2023, by the order dated 30th, 5/2023, passed by GMFC. In this number 726 of 2018, whereby non-bailable warrant has been issued against the petitioner. Mr. Naik learned counsel for the petitioner on instruction submits that his claims would appear surrender before the court below on or before 15th of December 2014, and resort to the remedy available to him under law. Taking into consideration the statement made in the back, the NBW issued on so and so is set aside, subject to petitioner appealing. And how much you will pay? How much you will pay? Your what's 1,000, huh? Yes, 1,000. Yes.
Item 16.
16. Yes.
Malad, the vehicle of the petitioner have been Malad.
This is 20 minutes. 20 minutes. I'll say. 15 December, obviously, the date which has gone, how will you surrender? Yes.
The vehicle Malad of the present petitioner have met with an accident that has been seized by the police. The petitioner filed an application for 457 release of the vehicle Malad. That was allowed subject to cash security of 3,25,000. Against that Malad I have filed here.
What is the valuation of the
valuation? The London court held that is the valuation. At that time. In place of cash security, property security, why the intention of the court?
You are the accused.
No, I am the owner of the vehicle.
What is the offense?
Offense rash negligence 279 and 30.
Yes.
As per the learning trial.
No, my lord. That is there, madam. That is there.
304.
He died.
279 304A.
Who is driving?
Madam, driver. I am the owner, man. Driver is driving.
Yes.
The learning trial court suffered the valuation of the bike through an
That is not dispute, madam.
What is tractor, madam? Tractor.
Paragraph 8, what are you doing by the way? Madam?
What are you doing?
I will mallet in the. I am doing business mallet.
What is the problem? You can pay money.
Business from the tractor mallet. Now the tractor is idle mallet. How idle mallet? In place of mallet cash equity, property equity, I am ready mallet. And if mallet
50% you pay cash, 50% immunity. Okay.
50% mallet, that is also very harsh mallet. I have taken the. You will accept 50,000 mallet cash and
what 50,000? 3,25,000 to the court.
But the intention here, Lordship, can you see the intention of the London court below? If I will not produce, then that will be recovered. But if I will file the property security, it can be recovered, my lord, from my property, my lord. I will try the property, my lord. That is the intention of the
1 lakh rupees cash security, rest property security.
Lordship कहीं से MSCD केस को वर्तमान नोटिस के आस्ते यदि क्लेम केस करियो जैसे बैंक के हेतु बाइक लोन ताले टंका से बाइक हम किसी फैमिली हैरान ही जिबे लॉर्डशिप नो एटा सिक्योर था 2 लाख लॉर्डशिप another is
नहीं she is not capable 1 lakh rupees cash security, rest amount property security. Finish. Right now, petition is agreed by the order dated judgment dated 24/7/2024, passed by the additional district and sessions judge in criminal revision number 11 of 2024, whereby the revisional court has confirmed the order dated judgment or order
23
order dated 24/2004, passed by the SDGM Anandapur in CMC number 49 of 2024, allowing the application of the petitioner under section 457 and imposing a condition subject to the condition that the petitioner shall deposit 3,25,000. 3,25,000. Next, the petitioner is agreed by the condition, by the onerous condition onerous condition for depositing 3,25,000 cash security towards the release of the vehicle. At the outset, Mr. Das, learned counsel for the petitioner, submits that the condition, the financial health of the petitioner is not suffice for the to comply the condition. Hence, he seeks leniency. But taking into consideration the submission at the bar, I am for the considered view that the petitioner shall furnish a cash security of 1 lakh rupees, and for the remaining 2,25,000 the petitioner shall furnish property security. Subject to furnishing the cash security of 1 lakh rupees and property security of 2,25,000, 2,50,000 कर देते हैं, 2,50,000, 2,50,000. The vehicle number so and so shall be released. Yes. With this modification, the present petition is partly allowed. Okay.
70. May I plead your lordship? I have been charged with 376.
The 16th Renarwood. Petitioner is the owner of the vehicle and not arrayed as an accused in the which was the affair?
Yes, sir. So the affair is
not arrayed as an accused in PS case number 113 of 2024.
And I'm going to see. GR case number 1, 2 up to 24.
For offences under
section
279 304 capital A of IPC.
279 4A
of 304 capital A of,
and there is section 181 of MB Act.
And section 181
of the MB Act.
Yes.
70.
Yes.
May I plead your lordship? I have been charged with 376 and POCSO 6 and SCST Act. Actually, as per the deposition of the victim, that it is a law affair which has gone sour. After the trial, actually after 8 years, the victim wants to make a compromise and we have asked for a recall petition. We have given a recall petition under 311. And now that the Honorable Learned Court on the dated 21/8/24, that is page 32, Annexure 3, because we are not there. Actually, there is a misunderstanding. We thought that date is on 24th August and we never attended on 21st August. So the petition was quashed. So
petition was
rejected.
It's not heard on merit. Yes.
Yes, sir. So, kind glance page 32 also.
Now, I'll just simply say what I'll say is 311 application is moved and it was dismissed. Simply, I'll restore it, let him argue, whatever. Let him argue. I will not say anything.
Yes, sir.
It is simply rejected. Just see. Come to page 32. And 21/8/2024. Order. Accused so is absent.
Yes.
And allowed to be represented by his counsel today on. The case is posted for today on objection and hearing of the petition so by the advocate for the accused. None is present to move the petition so. It is dismissed.
Yes, only.
And non-prosecution. Basically. I'll restore it. Whatever you want. Well, it is similar. I don't know happen. Well, similarly on 28th August 20th, the order before that, actually that day we have moved the petition. So that's why we are not giving the time petition for adducing evidence. So that was also. I'm only restoring. Those the things, my lord. I'm only restoring that. Right off. Petitioner moved an application under section 311 CRPC seeking recall of which witness? Which witness? Your petition.
PW 1 and 2, your lordship.
PW 1 and 2. PW 1 and 2.
Yes, sir.
PW 1 and 2. The said application has been turned down, rejected without hearing on merits. The impugned order dated 21/8/2024 reads as under page 32. Reads as one paragraph. Right. Perusal of the aforementioned impugned order reveals that the application under 311 CRPC could not be heard as the counsel for the accused petitioner was not present at the time the application was taken up. Hence, it was rejected. Since the application has not been admitted to on merits, I'm of the considered view that the same shall be restored to its original file, and the trial court shall afford an opportunity to the petitioner to be heard on its own merit. Accordingly, the order dated 21/8/2024 and passed by ADJ cum Special Judge under POCSO Act Bolangir is set aside, and the application as a sequel. The application moved by the petitioner under section 311 CRPC is restored to its file to be heard on its own merit. With this observation, the petition is disposed of. Next.
18. My lord, much obliged.
Yes.
University for seeking for quashing of the entire criminal proceeding on the grounds pending of the civil disposal also. But
let them come.
Yes,
We'll see. Yes, pass over.
19.
Have filed this application for quashing of the proceedings because intelligent already there is reverse. And the reverse is a compromise and the compromise is specifically then what particular.
Where is that? Compromise? Right on.
Compromise.
It is the FIR, nothing you file. Where is the FIR?
I have only filed the.
Where at least you should file. You have not filed anything.
I have filed the charge sheet.
Petitioner is seeking petitioners are seeking quashing of the order dated 21. Okay. Order dated 21/12/2019, whereby cognizance of offences punishable under section 498A/323/406/34 IPC read with section 4 of DP Act has been taken against the petitioner. The counsel for the petitioner submits that the petitioner number 1 petitioner number 1 and opposite party number 2 had already moved the civil court for dissolution of their marriage, and they have arrived at a settlement. Pursuant to the settlement, they filed a joint affidavit before the Family Court number 1 Bhubaneswar in CP number 134 of 2019. Divorce is granted.
Yes.
Relying upon the settlement terms, the Family Court 1 Bhubaneswar has already allowed the CP number 134 of 2019 by order dated
12/2/2020.
by the order dated 12/2/2024, resolving the passing a decree of dissolution of the marriage between petitioner 1 and opposite party number 2. The learned counsel for the petitioner further submits that in the settlement terms, it is also agreed that the criminal case pending qua the present petitioners shall also be withdrawn. Shall also be withdrawn and or quashed on the application of the petitioner. Issue notice to opposite party number 2 or within a week. When can you bring them? Tomorrow? No, don't do that. You make it on 26th. 26th.
26, I will not get on 27 or 28.
28. Okay. Let them come in which I quash it. Yes.
Both husband and wife.
No. Accused person should be there. If accused person can't come, I can understand. See, the father-in-law is 70 years and all.
But
They will not come, but move an application for exemption.
Yeah.
Here. Why can't they come? You just write the reasons for not attending. Move an application and allow that.
Why I say for December? Because they all are staying in Raulkal. I do not know.
Husband and wife are there. Let them appear.
I think they will go this one. But
Then let them appear through VC. Insofar as the other petitioners are concerned, those who can't come, move an application for exemption before this court. This much concession I can give. Okay. And let it be on 28th. Issue notice to opposite party number 2. Leave the matter on 28th. Yes.
I think
28th.
Yes. Here, question of proceeding matter on the ground matter has been compromised between parties. Item 20 and 23, both are same related. Case and counter case.
What are the offences?
Offense 307 is there. Both present 307 and other offences is there, my lord.
I am for the informant matter.
He is the informant in 20.
Have you included the injury? Injured? Yes, Patel, why are you filing this kind of petition always? Every time you file this kind of petition without including anyone. No informant, no injured.
Because I am for the informant.
No, just see the first petition.
I did it correctly.
Mr. Patel always files like that.
Sorry.
I'll allow you pay to the bar because you are a member of bar council. You must pay 5,000 you pay. He has to pay because every time he does like that. Pay 5,000.
My mistake. No, but Kali miscase to file.
You don't do whatever you want to do.
23 is same.
Why are you filing? These are minimum is informant and injured.
Yes, I'm sorry.
It is from next week.
Next week admit.
See, 23 is also like that. Don't include anybody, but
20
include to 20. Yes. 22 and 23.
Yes.
Mr. Patel and counsel for the Mr. Patel and counsel for the petitioner seeks permission of this court to include the necessary parties, namely the informant and injured in the present case. The prayer is allowed. Mr. Patel the petitioner is directed to include any petitioner may include the informant and injured within 2 days, subject to paying a cost of 1,000 rupees to the bar association. Okay. Bar council. Bar council, you pay and you spend that money for yourself. What do you mean? You pay the bar association.
Item 20 to my senior. Say, one petition opposite.
You pay 1,000.
Both the cases 1,000.
1,000. You make the bar association richer by 2,000. Yes. 22 and 23. 20? No. 20, item 20 and 23. Yes. Okay, 20 and 23. Okay. And you bring them also on the same day.
Yes.
So instead of issuing notice and all,
Yes,
you bring them so that and get the injured reports.
Yes.
Injured report if you get, just we can see that and decide. Okay. I'll just come. Okay. Then 363. Compromise. Where are the petitioners?
Petitioner is there.
And opposite party?
Opposite party. Two there is there.
Right now, at the instance of the petitioner is seeking passing of the entire criminal prosecution initiated against him at the instance of opposing party number 2 in GR case number 101 of 2023 arising out of Nikiria PS case number 50 of 2023 for arrays of section 363 IPC. The matter was taken up for hearing yesterday, and the following order was passed. Following order was passed. Pursuant to the aforementioned order dated 19/11/2024, Mr. Jana, counsel for the state, placed on record the written instruction received from IIC Nikirai PS. The written instruction reads as under. Written instruction reads as under. The paragraph the parties, when the investigation of the present case is still going on, at this stage, parties have settled their dispute. The opposite party number, the petitioner and opposite party number 2 are present in the court today, being represented by their respective counsel and identified by them, and they filed the self-attested copies of their Aadhaar card to establish their identity. They have also filed a compromise affidavit dated 14/11/2024 inter alia stating agent. Compromise affidavit is there already. Just see para 2, 3 and 4. Para 2 and 3. 2 and 3. Regard being head to the Mr. Janam and counsel for the state submits that since the offense is only against only under section 363 CRPC, no graver offense has been added as yet. An investigation is still going on. At this stage, since the parties have settled their dispute, there is no legal impediment in quashing the FIR. Regard being head to the aforementioned and the judgment of this court in Gantt and so on. So it's quashed. Yes.
Nice, my pleasure.
22. Yes.
After separate living for more than 5 years, the petitioner, the opposite party filed an FIR against the present petitioner, who is the husband of the opposite party, under section 498A, my lords. So this CRLMC is filed for quashing of the FIR, my lord.
My lord, a copy of the no copy.
Other, government to nahanti, private opposite parties.
No, you have to make government also party. How is it FIR 498A? The state is investigating.
My lord, I will make, and also I will give the copy, my lord.
See, informant will be opposite party number 2. The state is necessary party. Unless you make the state, how can it be quashed?
My lord.
Investigation has already been completed, and charge sheet has already been filed, it seems.
My lord, also there are 2 diverse cases pending, my lord. By the wife against the husband, 1 divorce case is pending, and at that time this 498A application is filed, my lord.
No, on merit, if you go, then you may not have a good case. But if you want to settle, I can think of sending a notice to.
Then I will make the state as a party.
The petitioner seeks permission of this court to implead the state as opposite party number 2. Opposite party number 2. The permission is granted. If you notice to permission is granted to implead the state as opposite party number 2. Mr. Vishwal accepts notice for the newly implemented amended new parties will be filed within 2 days. Mr. Vishal, learned counsel, then accept notice for the state. Issue notice to opposite party number 1. Reasonable inference also. Yes. Implead and and give a advance copy. Okay. Okay. After 3 or 4 weeks, yes.
Yeah, item number 24. May I pray that the Jagannath Temple administration may be right. I am challenging the FIR, which I pray for quashing. The state machinery has registered it as FIR. Why should the state? Who is the informant? The informant is an employee of the Jagannath Temple administration.
See what is the case is about.
Now what's my seizure?
Generally when there is a chance of settlement and all, we insist for information.
Yes.
Otherwise, state has to do it.
Your Lordship may see page 13.
13. Yes.
They say, in inviting a reference to the subject cited above,
yes,
I so and so, who is Deputy Administration Revenue SJPA Puri, inform you that a lease agreement was executed with petitioner with respect to operation of Dhania New Building Stone Quarry on dated 5/10/2023. Well, also may mark this date. The agreement was on 5/10/2023. On the basis of being the highest bidder in the auction conducted on 2/8/2018. Then he says, though the leaseholder got environmental clearance on 3/3/2022, he suppressed the matter, handed over the EC on 14/10/2022. Declared deposit the royalty and other dues amounting to 58 lakhs and odd as notice paid by letter dated 11/11/2022, and the allegation is in the meanwhile, leaseholder without execution of agreement and necessary blasting permission from the competent authority has extracted illegally building stones from the above quarry. These 2 lines are the allegations against you. Now let us look at the next paragraph. It is reported by the mining consultant of SJTA, Sri Chandrabhanu Das, that there is an extraction of 1,47,873 cubic meters of building stone from the quarry to active steel pills. You also may mark this date. Up to the year 2023, petitioner was noticed to deposit 2,90,24,702 within 15 days by office letter dated 8/11/20, which he did not deposit. Even though he received the letter on 22/11, and he was again noticed on 2/8/24 to deposit, but he has not paid any fee, and he was dishonestly misappropriated minor mineral.
Yes.
And therefore, he says that necessary criminal action may be taken. Now, I am again emphasizing on the report of the mining consultant, SJTA, on which the FIR is based. Would your Lordship look at page 17?
17?
17.
Okay. Yes.
That is the report of the mining consultant SJTA. What he says, your Lordship may see. This letter is addressed to the Chief Administrator SJTA Puri. This is to bring to your notice that the volume of excavation depicted in my report dated 26/6/23 includes total excavation of stones from the quarry during the period of survey of the mining plan, that is in 2019 to May 2023. Then the important sentences, as revealed from your above referred letter, lease has been executed with effect from 5/10/2023. 5/10/2023, the executed lease with me. Then he says, as per rule 43(2) of the rules, quarry lease is valid from date of registration. As lease was not executed till May 2023, present lessee would not be responsible for the excavations made within the quarry lease area before the execution of lease in his favor.
Is it your case that without without the
lease agreement, he can excavate the quarry.
Okay.
My submission is this. One of the
One will complete. Let him complete.
Let me complete.
Yes.
My submission is this.
Yes.
This SJTA chief, the RQP says that the lease is executed on 5/10/2023.
Yes.
In the FIR also they say lease is on 5/10/2023. Though in the FIR they say that they are 150% telling. In fact, till the
Yes.
Well, how could I extract?
Where is your reply to the Shokas notice?
My reply. My reply in Annexure 3.
This is the Annex.
Wherever 18. Oh, sorry. I'm sorry. This is not. No, I have not annexed the reply.
Get that reply when the Shokas notice was given to you for the demand. Because the impact of common cause in this common cause judgment.
This has to go Millers. I mean, no one liable. Their own documents say,
No. See, the demand of whatever demand is made, yes, some crores, whatever demand is made. And you have to wait till
the defendants have stayed. I have come before. I have challenged it in the
Shokas notice. To get that order. See, unless that is determined, suppose you have ultimately it will be decided that you have to pay this amount. Then the presumption is you have carried out the excavation.
No submission that it was soon. Tanto FIR say constantly, the mining consultant Kanchi, I have excavated. I placed the letter of the mining consultant. He himself is saying, I am not the person responsible.
No, this letter which you read out at 17.
Yes.
Let us read it once again.
Yes.
Let us understand it.
Well, let us read page 13 before that.
Page 13.
Yeah.
Okay.
Page 13 was second paragraph of Lordship may see.
It is reported by.
Yes.
It is reported by the mining
consultant SJPA.
There is an exception.
That there is extraction of such and such COM of building store.
In lieu of that, the demand is made.
Yes.
Okay. In lieu of that, demand is made.
Yes.
Let us come to 17 now.
Yes, Millard.
Now, and which demand is now stayed by the division bench according to you. That
division bench says no course of action is with
notice. That notice you might have changed. Okay. Next,
what does the mining consultant say?
Yes. This is same Chandravan.
Yes.
CV Das. Yes.
This is to bring to a notice that volume of excavation depicted in my earlier report dated 26/23 includes total excavation of stones from the quarry during the period of survey of mining plan. That is in 19 till May 2023.
Right.
As revealed from your above letter, lease has been executed with effect from 5/10/2023.
That's right. That is their case. They say that although the lease was executed on 5/10/2023, prior to the lease being executed, you have done this.
Yes, second paragraph.
Notices.
Look at the second paragraph.
Yes. So the quarry lease is valid from the date of registration of the lease. As indicated, lease was not executed. That's right. Till May.
What does he say?
The present lesson what you're trying to say is thing is coming forth to show that possession is given to me. That
I am trying to say is that I am not responsible. That is what it is. Manner, this is the present lease would not be
is not
why this is the legible copy of the Annexure 2 that the
last line up to that letter, page 17.
My knowledge is relying on that would not be responsible.
No, it says, what is the case accused to be?
Yes, ma'am.
Your case is
division bench.
Under 2019 to May 2023.
Yes,
he has undertaken that excavation and extract.
No, not I.
That is your case.
Yes, I have.
That you issue notice for recovery.
Yes.
And you are relying upon complaint, you are relying upon CV Das report.
Yes.
CV Das in his report says, last line C.
Yes,
As in this context, leave was not executed till May 2023.
Yes.
The present lessee would not be responsible for so and so. If you are relying upon the same report to lodge the FIR, and he says that he is not responsible, how will you?
Therefore, I am saying this letter, this is the legible copy he has typed out. The original letter, maybe this law, that law, maybe
missing.
Therefore,
He makes that allegation without realizing against whom he is making the allegation.
No, it's not making.
40 years, Millers, I have never come up before this law, before this court. No, it's not any letter. But you want to get it confirmed, I am telling it. I am sorry that my lawyer friend makes such an allegation.
No, it's not allegation. Don't take it.
I have prepared it as a legible copy. I'll put it next to it. This is the allegation that he makes.
I will put it next week to verify this.
Yes.
And the last line,
Yes,
the last line is to be believed.
Yes.
Then your FIR is false.
Yes, yes, yes.
So therefore you have to examine this.
Yes.
I'll just put it next week. They verify it. Okay. Don't take it as an allegation.
It is, my lord. It is.
Sometimes submissions are made.
No, because of some people who never come to court, but now they are catapulted into court appearance. So they say everybody is a chore.
No, don't take it that. Don't take it that. Okay.
Unfortunate.
Okay. 25.
Item 24, Lord. The parents-in-laws.
Parents-in-law.
Yes, madam.
Yes. 68, 65.
Yes. The respondent and bonus Nial, who were practicing advocate from this court, but and a lady from Tripoli, they had relationship, and they 2018 they got married. And marriage was consummated throughout at Tripoli and I had cut off. Therefore, in the rented house at Sibo Sector 7. And in subsequently, this petition was to 12 the DPA. Highlight and except to page 19.
You are seeking quashing of this FIR.
Yes. But
what are the allegations against you?
University only was page annexed to page 19.
Come to page 12.
Yes.
Yes.
No, page 12 is the 490 matter, that is for this matter. Page 12 is that 490 against the in-laws as well as the husband. It is pending. So that annexed to that proceeding in the DPA 19
yes
is under challenge, my lord.
That what are the allegations here? What is is asking against you?
Yes. Page 21.
Yes.
Details of previous litigation. That the agreed person complainant is the legal married wife of respondent number 1, Donis Nial. The marriage between the agreed person and the respondent number 1 was solemnized on 7/27/2018 as per Hindu rights and customs. And
no, what is the relevant part? Why
yes,
yes. What is he asking?
Yes. See that 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. That 15 days after marriage, must got it, my lord. That period is 1, 2,
from the below.
You don't tell me irrelevant thing.
Yeah,
I'm telling you what are the relief.
Yes, you're also saying
where is that clause? Relief.
That is there. You'll also see that page 20 then, my lord.
Order required.
Yes. Page 12 that order required protection under section 18. Then section 19 that residence.
Yes.
And 20 that loss of earning amount claimed and loss of removal of property. So that
yes, you are saying in the same come to the address.
Yes.
Come to the address.
Yes. It is page 19.
Yes.
Yeah, the petition of Ganesh Nial, originally he is from Kontavani district, Bolangir. And since 2010 he is staying at Cuttack. So, but one who happens to the husband. And 2 and 3 are the resident of village that.
Where is your reply to this section 12 petition?
My lord.
Have you replied to
the husband has appeared and we are yet to.
No, what about you? Have you replied?
No, not yet replied.
No, then You don't even reply. You must reply
Yes, that is
to
it.
that. And you say that we are staying separately, I'm not staying with you and all these things, unless you tell me,
That's
try for. On what basis it can?
husband has appeared and he's
Husband might, yes, so you are talking about
yes.
the in-law then.
Yes.
You go and file reply and seek for.
No, I'll file reply. May I say that let notice be issued to OP number 2 that I have made her party, the complainant in the section 4 proceeding.
See, you try to appreciate what
I do. Yes.
See, you go and you need not appear, you can appear for counsel. There is no problem. Your son is already appearing.
Yes.
You file reply before the court and seek for dropping your name, being unnecessary party. Straight away file for AGT petition without going to trial court. And without there being any pleading, without there being anything, how can I assume everything and
I stated that possibility of settlement also cannot be.
I'll just give an opportunity to go and appear before the trial court, and I'll give direction to the trial court to explore the possibility of settlement. I don't. Petitioner is seeking.
They cannot appear.
Petitioners they can be printed through 1 minute. I'll try to. Petitioners are the mother-in-law and father-in-law of opposite party number 2. Opposite party number 2 has initiated a proceeding against the present petitioner and her husband and other members of the family under section 12 of DV Act, exploring various relief. The petition, the section 12 petition being ICC number 31 of 2024 is at a very nascent stage. At this stage, the petitioners have approached this court for quashing the proceeding, qua them. I am not inclined to entertain this petition at this stage, as the petitioners have not even filed their reply to the impugned petition under section 12 filed by the opposite party number 2. Once a penalty is granted to the petitioner to raise all the points before the trial court, and seek appropriate relief before the court below. Each such application is moved, the trial court is directed to deal with the same on its merit and decide the same within 4 weeks from the date of receipt of the present order. The trial court is also directed, keeping in view the age of the present petitioner and the nature of allegation made against the present petitioner by the opposite party number 2, it would be expedient on the part of the trial court to make an endeavor to see that the dispute is settled amicably. Accordingly, the trial court may explore the possibility of settlement himself or refer the matter to the mediation center. With this observation, the petition is disclosed. Move the application.
Yes.
Within 1 month, it will be decided. The trial court is directed to explore the possibility of settlement or send it to mediation. Everything is done. Yes. With this observation, petition is disposed of. Yes.
Lots of no pass over this letter after now.
Sorry?
Pass over this.
Pass over.
57.
Yes. Item 27. Also that. Yes. Applied for quashing of the proceeding. Applied for OP number 2 as the informant OP number 2. And also see the allegations at page 11. The petitioner is on the OP number 2. They hails from the civil tribe community from Noapada district. Both are laborers. And also in 2012, he said they went to Chhattisgarh. 2014, they went to Ayodhya. Both are major. And they prefer to keep legal relationships stay together. And after lapse of almost 2014, lost this affair. And allegation is that the opposite party knowing fully well that and not the legal judgment, people they will for months together at Ayodhya and Chhattisgarh, and on being disputes or marriage lost this affair. And I also like notice this to he is ready and willing to settle the dispute.
Allegations are, have you seen?
Yes, I have seen that.
Allegations are very serious.
Yes.
Allegation of rape and all.
Yes. First is it both belong to same village, both are from health and civil right community.
If you say they have settled the dispute, why should you make the court as a party to that? You bring them. I'll examine. I'll issue notice. And it is a, why should the court will be a party for the purpose of your settlement? You bring.
You will keep it next week, I'll bring.
I'll just simply, I will not say anything. I will not issue notice. If at all you have settled the dispute in a case of this nature,
yes, sir,
where there is a rape allegation and all, you have settled, then bring her. If she says, okay, I am not willing and I am examining whether it should be quashed or not. Allegations are serious.
On the ground that both have settled their disputes. And
settled doesn't mean see the offense against the state. It is not see just see the allegations. Just see the allegation. Page come to page 21.
Yes.
Quashing is not a routine job.
No, that I do it, Mr. Fellow.
Not to settle the dispute and quashing. Allegations are so serious.
So initially occurs to place 2012.
Then again you are going on merit. Then it's something different. Then not examining.
Yes, you also keep it on last week of December.
December first week.
First week. In the meantime, we'll take step for both to let the plot.
You do whatever. I am not saying anything. You take December first week, you bring that.
Yes.
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 Yes. Yes. Father-in-law of the petitioner. Petitioner number one. There are two petitioners. Father-in-law of whom?
Yes.
No, there is no order. Have I passed any order? I am not passed any order. You have challenged the community order, you have not filed even release this matter along with give the number 374, after first speaker, second week. Yes, next. Not tomorrow. Yes. Next.
Wait, please, Yes, I filed this application for quashing of the criminal proceedings, my lords.
Yes.
My lords, this essentially is a civil dispute first.
Yes.
Initially, the FIR was registered under sections 294, 323, 34 and SCST Act.
Yes.
Subsequently, in the charge sheet, SCST Act has been removed, 506 has been added.
Yes.
However, my lords, a glance at the charge sheet itself shows that it's a civil dispute, and at whose behest the whole incident started, they have not been charge sheeted. And pursuant to this, on the second day, the complainant, they hit us and we were seriously injured. We gave the FIR first, which is Annexure 3 series, and the charge sheet has also been filed. Now, to counter us, they come and give just a blank FIR.
Which one?
Which is Annexure 1, my lords.
Now, what is this charge sheet?
Charge sheet, my lords, may kindly see page 27, the allegation starts.
Okay.
There, the whole story is our land, the complainant was over our land, we sought rent from him, which is evident from around yes, my lord. So, on that basis, a small altercation started. However,
that small altercation which you are saying, which resulted in 323 and all.
Nothing, my lord. The injury is also simple in nature.
But the criminality, that is very similar about it.
Where the civil liability starts, the whole altercation, those two persons are not
right. It started from a civil liability.
Yes.
And you became uncivilized and started attacking people.
There is no actual attack. Malach may kindly
That I existed, I can't.
there is the charge sheet. This is
Yes, I'm there. I exactly am there.
Malach.
Yes.
I'm grateful, Malach. On that very around
Yes.
around 17th line, it says, subsequently, I took charge of the investigation of this case. A copy of FIR has been supplied. The spot where occurrence took place is on the village in front of the house of the alleged person, Yudhishthira Sahu and Jyoti Sankar Sahu. The house of Vijay Behra is on the west and Kartikesha is on the, there is a triumph square. And besides this, no other incrimination articles are found during spot visit. Investigation of the case transpired that complainant Prasanna Swain is a farmer and earned his livelihood by cultivating vegetables on the subleased land of one Gokul Swain, of village which Gokul Swain has taken on lease basis to share the cultivation from one Yudhishthira Sahu, who is the father of the
Last 5-6 lines, you get it. What are the offense? You have assaulted him and see the way you have scolded him. All these things are
these are allegations, Malach. There is no, and he says, Malach. I bow down to that observation, Malach. All I throw, Malach, may notice, I don't want to say, it can be amicably settled from this court itself.
Tell me, I'll quash it.
Then
the offenses are weak.
Malach, just adjourn it. I'll
bring him, I'll quash it.
Because Malach, 323 is not made out. And SCST has been dropped, and at the behest of whom?
I understand it. See, the allegations are not very serious. And therefore, if you bring 323 and all, I can quash it if you bring them.
Because criminal case is lying on my head. I'm a contractor, I do contractor work, so allegations, this affair is
absolutely right. Shall I send you to mediation?
Management send us to mediation.
A small dispute. I issue notice and they said
because it is upon our case, they subsequently just drop in and file
listener is seeking quashing up for the Tumsinga case number 50 of 21. 21 initiated by the opposite party number 2. This is a cross case being filed by the opposite party number 2 after the registration of a FIR by the petitioner against him or her. Against him. Learned counsel for the petitioner submits that the allegations are not serious in nature and there is a possibility of a settlement between the parties. Issue notice to the opposite party number 2, which is Vigilance, except notice for the state. Regarding head to the nature of allegations made in the charge sheet and the statement made by the learned counsel for the petitioner at the bar, I'm inclined to refer the matter to the mediation centers. Where are they? These people?
These people are in
District Mediation Center. District Mediation Center, Denkanal and Seizure. Yeah, awaiting mediation report leased on. And the coordinators shall issue notice to opposite parties also. And the counsel for the petitioner also undertakes to the court that he will communicate this order to the opposite party number 2. So,
Let's may pray until then stay off for the proceeding.
In the meantime, the counsel for the petitioner is given liberty to move application before the trial court, seeking an adjournment owing to the fact that the matter has been referred to mediation.
Yes.
30. May please. Petitioner has filed this petition for quashing of the entire criminal proceeding. Your Lordship and your Lordship may see page 13. This is
1-3?
Yes, ma'am. This is the affair.
How do you state
why I am saying, madam, because it is a political motivated case. The MLA has given an FIR against me, and I am the ex-vice chairman of the block, and there is a dispute relating to money. From the FR, it is evident. Your lordship may see the
Yes.
the bill, आंबे अतलाकारी भारतीय जनता पार्टी तरफ उदय निर्वाचन मंडल पर दलित प्रार्थी टिकट पाइबा घोषणा होगा पर केते नक्सलवादी गोष्ठी व्यक्ति विशेष आंबे ऊपर राजनीति या प्रोसेस टिकट करने उद्यम चलाइथिले 30/4/2024 रे. This is the important matter.
You are from which party?
I am all Vigilance father. On 34 to
You change your loyalty, then everything will be settled.
it can be settled if notice will be issued, because what happened, my lord, in 3 STSs added there, because there is no allegation relating to 3 STS also.
That's right, you change your loyalty.
And apart from that, the now charge sheet has been filed against me only. Others have been, and in the charge sheet and news there is
Little political. Little political. I'll just issue notice, Lada.
Yes, ma'am.
Issue notice. Returnable so and so.
I am permitted to file examined petition today that has been placed.
Urgent. Please. Take out notice, let us see.
Today the date is there.
No, you move adjournment application. That I have said, but take out notice by tomorrow.
By tomorrow.
Let us see if he comes, we will find out.
Both are belongs to me.
I'm sorry.
Same everything because
One item.
your lordship may protected me.
Yes, that I pass. Yes. Yes.
Item 66 in your office board. Both the parties are there.
Okay. 66. Let us take it. I'll just take it out. Parties are there. Why to retain them? Okay. 34 also? Okay. Let us do first for 34. Okay. 34. Yes. 34. 307.
Yes.
307. Show me the injury report. Show me the injury report. Injured is a party to this proceeding?
Yes, injured the
Digambar Purida. Informant and the injured.
The father of the injured is
Who is injured?
the son of the informant.
Where is he? He is in mid party.
Informant
Where is the injured?
injured has
Urgent. Next, PCH report.
not
307, you don't implement injured. How do you think that will be done? Yes, PCH report.
injured also come. I am adding the as a party.
You heard it, then we'll see. Yes. These are fundamental. I can't wait for this. Out of 10, I pick out the file and you have not.
It will also take up this matter up to 10 and correct.
Do whatever. I'm just passing it over. Do whatever. Soft copy is not there. You don't implement necessary parties. Quashing.
Then you'll also.
Quashings are not routine, sir. 307. I need to know what is the injury.
The power of the.
I need to know. I need to see the injured also. Whether it's survived or died because of the injury caused by you. Yes. Simply adjourn to next week. Yes, next 64. Yes. Yes.
I am appearing for the informant and my learned friend is appearing for the petition. And for reports, I am filing an affidavit on behalf of my client and matter has been settled. Now a joint affidavit is.
What are the allegations? Yes.
My learned senior Mr. Nayak was yesterday appearing. Sir, call by.
Oh, so yes. Who are the parties that of Salini Patnaik?
Shravani Patnaik and Mrs. Sucheta Mohanty. Sucheta Mohanty is informant.
No, Sujita Khotoi.
Khotoi Mohanty. Khotoi is her husband's title. It's
Where are they? Who? Suchita.
Sucheta Mohanty.
Suchita. Your Suchita. For alleged offences under section 289 and 338 IPC. The allegation against the petitioner is so and so. When the trial court by the order dated 28/11/2023 has already taken cognizance for alleged offence under section 289 and oblique 338 IPC. When the matter stood thus, the parties have settled their dispute. The petitioner and opposite party number 2 are present in the court, being represented by their respective counsel, identified by them. They have also filed the self-attested copy of their Aadhaar card to establish their identity, which are taken on record. Have you filed affidavit? Yes. The petitioner and opposite party number 2 have filed a joint affidavit dated 20th/11/2024, inter alia, stating as under.
My lord, 338 actually, not 388. Pardon to mention.
I know 338. 338. 429. 429. The opposite party number 2 has also filed a separate affidavit dated 20th November 2024, reiterating her stand. On query from the court, the opposite party number 2 has stated that her son, who was the victim in the present case, is now 10 years old, and she says that there is no complication there is no health complication her son suffered. Therefore, she doesn't want to proceed with the present case against the petitioner. Regarding head to the Mr. Vishwal appears for the state and submits that since the parties have settled their dispute amicably and filed the affidavit before this court, and there is no grievance for the petitioner, opposite party number 2 against the petitioner, and hence there is no legal impediment in quashing the FIR. Regarding head to the statement made at the bar and so and so, Gyan Singh so and so quashed. Yes.
I have sought copies of the joint.
Yes.
Obligation.
With the losses provision in item 34, only warrant may not be executed.
You have filed an incomplete petition. You said that I have settled the dispute, and now you want an interim order. Is it possible?
All have come, but I need to.
In 307, where is the injured? I'm asking.
Injured has also come, but it is my mistake that I have not made him as a person.
You have to be fair to the court also. Where is the injury report you show me? Injury report is also not there. You have not filed. 307, I will cross it on the basis of your statement. I can dismiss also, saying that it is a case of 307.
Yes, sir.
Then? The court is not even entitled to know what are the kind of injury sustained by the injured. Injured is not a party. You have not filed the injured report.
Yes, sir.
And you want quashing and interim order also. Over and above that.
Okay. Till then, may not.
No. I can't, you don't file the petition properly. You don't file any document, you need interim order. You do that, pass it over and you do whatever you want to do. I'll take it up at 3 o'clock.
31.
Don't make, see, if a reasonable request, I'll definitely entertain it. It's not reasonable. You try to little fair.
I'll put it on
Friday. I'll put it on Friday.
I am committed to add this.
You do it and file an amended of parties. I will list it Friday, bring them, I'll try and do it. And come with the injury report. I am again telling you. Come with the injury report.
Yes, sir.
Place it on record.
Yes, sir.
I want to know what are the injuries. Yes.
31. In item 31,
yes,
petitioner challenged the order taking cognizance of offence. Petitioner and opposite party number 2 are a husband and wife. Now the dispute has been settled and they are living.
Where are they?
I mean, listed for the first time. You will also kindly.
What first time settlement? You bring them.
Yes, my lord. You will also kindly fix it.
What are the offences?
Offences are. 294, 341, 325, and 307 is there now.
What are the injuries?
Injuries, as there is a tussle between the husband and wife.
Now they are staying together.
My lord, my
They have
lord,
settled.
my lord, that's
So
it.
anyway,
Since 2023, my lord.
bring them.
My lord.
Or 2 o'clock.
No, no,
Online, you bring them online and watch it.
petitioner is at New Delhi. He is working as in the bank. My lord. You know,
Then what happened? They can come at online. What is the big deal about it?
next week, your lordship.
No, online you bring, you try. Don't make statement. You won't tell online. Yes, next.
Okay,
Let them appear for 2 minutes and cross it. Why are unnecessary? These matters are unnecessary pending.
My lord.
Tell them to appear online.
My lord.
And she is also appearing for informant. You are appearing for informant. Tell both of them to come online.
My lord.
I will cross it. Where 3 o'clock, 3:30,
My lord.
whatever. Yes.
32.
It's based for question of the convenience. Right, answer 3, my lord.
3?
Yes, answer 3, page 16, my lord.
Yes.
Question of convenience. Passage is submitted on 8/8/2017 under 460 and 420 IPC.
Yes.
And this is charge sheet.
Yes.
Page number 12.
Who are you? You are
I am for the
Partho Sarthi Das. Okay. Yes.
FIR is lodged Partha Sarthi Das.
What are the allegations? Charge sheet, come to charge sheet.
Charge sheet in page number 2.
Yes.
Some check has been seized. That the case is made in under section 138 in the Act, my lord. Not under section 420 and 463.
Yes. 138 is also pending.
No, 138 is file and not doing it.
Lordship, as per the charge sheet, only section 468 and 420 is made out. But no 138 has not been explained.
No, you read. What are the allegations?
5,23,000 has taken.
There was a business fallout between the informant and the present petitioner, and to the tune of rupees 5,25,000.
Yes.
Subsequently, he had followed up with the. He had stopped communicating with him. Stopped taking his call. That is what.
Nice. Read the allegation. Read the allegation.
During the course of investigation, I have examined.
No. The charge sheet says nothing. Come to the FIR. Come to the FIR.
One Sri Santosh Kumar Jena, who is working as manager in Cellmate, so and so, one retailer, Partha Sarthi Das, owner of Jagannath Communication, had been lifting Nokia stocks from their distributor point many times for his business, and was making payment in cash in the beginning against those bills. After a couple of months running smooth business, Partha gained trust from his sales representative and convinced him to start credit bill, which used to get cleared through part payments in installment. Subsequently, he started billing through long post-dated checks with an intention in his back of mind for doing fraud in the future. On dated 3/1/14, they came to know that their outstanding exposure on part was crossed beyond limit. He was owing like 5,23,895 to Cellmate. After all his fraud checks got bounced, they immediately stopped billing and went for a stock audit at his shop. Found there was shop was closed. He was not corresponding to them at that point of time and diverted his cell phone. Then they went to his residence and met Partha. When they asked for the stock, but he said no stock left with him at his both shop and residence. All their sold and money is being diverted for personal purpose. More to this, they also found all the bounced checks Partha used to give them. They are in the name of one Dipti Ranjan Maharana, who is a third party to the transaction, having no relevancy in business. When they asked Partha about this offense, he said he does not have any relation with the name of the guy, which is reflected in the check. In fact, he told that he always used him to issue checks for safety purpose, and he will do everything for him because he is obliged.
The allegations, not that.
No, my lord. This allegation is totally false, my lord.
Also, I'm not here to evaluate.
Yes.
But there are allegations.
No.
The cognizance is that is the reason cognizance is taken.
This is purely 138, my lord.
No, 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 no.
One of the employee has taken the check, my lord. One of the employee.
All these things are your, see, all these things are your defense.
Yes. That allegation made against me is the total false, my lord. I have not, I have given check.
False are what how can the cognizant say that decide you tell me? Allegations are there. Perhaps a case is made out. Do you argue at the stage of charges? That petition is challenged the order dated 18/5/2018, whereby cognizance of offences punishable under section 468, 420 IPC has been taken against him. I have perused the charge sheet and the document form part of the charge sheet. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to resort to the remedy available to him under law at before the trial court at appropriate stage. With this observation, petition is disposed of. New application for discharge and get it. Yes.
33.
Yes,
May I please, my lordship?
yes.
May I please, my lordship? I am the petitioners are seeking quashing of GR case number 430 by 2016 before SDJM court, Brahmapur, my lordship.
Yes, yes.
Allegations under section 354A, 294, 354B, 34.
What is the ground? Tell me, what are the grounds?
My lordship.
Grounds of challenge.
Grounds of challenge. The petitioners are learned teachers, my lordship. They are teaching in the institute and wrong allegations against that teachers regarding outraging the modesty by the complainant.
Yes, what are the
Lordship, clearly section 354A and 354B, as per the allegations, both of them are made out.
Tell me what are the allegations?
I will read the FIR.
Relevant part, don't read the full story.
ମୁଁ କଲେଜରୁ ରିଟର୍ନ ଯିବା ବେଳେ ପ୍ରିନ୍ସିପାଲ ପ୍ରଭାକର ସାର୍ ବିଜୟ ସାର୍ କଲେଜରୁ ତଳକୁ ପାହାଚରେ ଓହ୍ଲଉଥିଲେ ଆସୁଥିଲା ବେଳେ ମତେ ଦେଖି କରି କହିଲେ କଲେଜରେ ତୁମର ସାନ ଭାଇ ସୋ ଆଣ୍ଡ ସୋ କଲେଜରେ ବସି ମେଟେରିଆଲ ଜେରକ୍ସ କରି ଘରକୁ ପଳେଇ ଯିବ ମୁଁ କରି କଲେଜରେ କଥାବାର୍ତ୍ତା ହୋଇକରି ବସିଥିଲି 20 ମିନିଟ ପରେ ଦୀନବନ୍ଧୁ ପାଣି ପିଟିସନର କ୍ଲାସକୁ ଆସିକି ଲାପଟପ ଷ୍ଟାର୍ଟ କରି କହିଲା जो सिलेक्ट करी रखिछु मोर but he has used abusive things he has told एक प्रकार फिल्म मु देखे नाही कॉलेज बाहर को आसी जाईथिली एवं मटेरियल्स नी घर को चली गली
yes I read it yes sir what do you want to say
my lordship please see the page number 55 the informant is undergoing mentally treatment in MKCG Medical College. And her mother also stated that she is undergoing she is mentally ill and undergoing treatment.
See, the charge sheet it is otherwise. The charge sheet they say that they have tested there is no such a report.
Also, 164 statement also states this.
And these documents the cognizant says I can't go into. These documents are not form part of the charge sheet, which you are relying upon. Petitioner has challenged the order dated my petitioner
So the petitioners have assailed the criminal prosecution initiated against them at the instance of opposite party is also not there. Let's see. No. Petitions are filed like this, nothing is there.
The informant has not been made party.
Madam, petitioner which are petitioner are seeking quashing of the FIR number so and so and consequential proceeding arising therefrom. The allegation against the petitioners are such. The petitioner, by relying upon various documents placed as annexure 3 to the present petition, seeks quashing of the FIR. The documents which has been relied upon by the petitioners are not form part of the charge sheet, At this stage, I am not inclined to entertain this petition, hence the petition is dismissed. However, liberty is granted to the petitioner to resort to reach all the points before the trial court at the appropriate stage. With this observation, petition is disposed. Next year.
35.
May I please, Your Lordship?
Yes.
Here I am challenging the order of annexed over in annexed 2, order dated 28/10/2024, wherein rejected my application.
Yes.
It release of my license gone of the petitioner, which has been seized by the particular case, and it was clearly mentioned in the annexed.
You are not the accused in the affair.
I am not accused. I am unknown person accused. I am a businessman. If for my personal safety, I have been used my gun, a license gun.
You don't know the accused.
So that FIR is I have annexed as the unknown one. FIR is.
How it has gone to
but it has been used, what is stated in the FIR, and the vehicle was running mallet on the way. The vehicle was wants to try to run away from me. So I have kept my license gun in my pocket for my personal safety. And I used that. I have not used. I have not threatened to use. For that, the gun has been seized. I am filing the petition for release of that gun. And it has mentioned in point, kindly see, annexed.
Or during the investigation for the. You are not the party. You are
yes, but in page 21, kindly see, order of the informed order was last 4 lines. Is not required for the investigation. Whereas he has submitted send the copy of the license in the name of petitioner to the district order for cancellation.
Lordship, make beginning of that page, Your Lordship, page number 21 from the first paragraph.
21?
Page 21, Your Lordship.
Yes.
It is noteworthy here that the article so played for release, that is a pistol, is alleged to have been used in the commission. The article is the material object which might be required during the process of trial, and at this preliminary stage, when the investigation is yet to be completed.
Let the investigation which is seen in this case is no more required for investigation. Why the impulse during the investigation is not required? This has been released by interim release, not final. I have submitted, as I am required in the investigation, I will submit before the IO matter. I will not never change the nature character of the property matter. But the decision of the maybe Supreme Court in that 2003 share, so thereby I am not in this case matter. It has clearly mentioned that has been any property, the powers should be exercised promptly and judiciously, and articles should be not kept in the police station for more than 15 days to 1 month. And otherwise, our High Court, the 85 OCR 705 in the Assistant Mahanta case also, categorically mentioned that the property should be only in favor of the petitioner matter. That is the entry rules, not the matter of if the investigation doing the investigation before I introduce before the investor also. The condition may fixed, I will produce before the investor also. That will be released in favor of me.
You seek instruction. Seek instruction. The investigation is still going on.
Yes.
See,
my lord. Not final. During the investigation, if the property is required.
Suppose they seized it, they want to take fingerprint up from that.
So I'll go for the investigation.
How you that if he's willing, then it will be tempered?
No. How I will not never change. In judgment also there, I will never change any nature character of the property, my lord.
You will not hold it also.
No, I will hold. I will keep.
Once you hold it, suppose there is some fingerprint.
Yes.
in the selection.
Yes.
Investigation is going on.
Yes.
They will send it for reviving that fingerprint.
Fingerprint.
If it is released, how will they do?
It is clearly mentioned that he is not required for investigation. He is not clear required for the report has submitted.
See the PP statement.
Yes,
Which is surprising.
in this stage is no.
PP says it is surprising. As how the investigating officer says that it is not required.
So, we sent to ballistic expert opinion. It is doing trial. It is the trial. But since long in trial, for filing charge sheet, they will have to collect all these evidence.
Wait, I just want to know.
Yes.
What is this says? I am just issuing notice. You issue notice, let's check it up and you just whether this weapon is required for investigation or not, you tell me. It is not required, the interim release I will do it.
Yes, interim
is required, then it's something different.
Yes, let the IO come. Yes, my lord.
Yes, issue notice simply. Yes.
The subject may please, my lord, a long time already passed. Lordship.
You want to kill someone?
No. Then for my personal safety, I have the license gone. So I am a businessman.
When it was seized?
My lord, since long, my lord.
Lordship, moreover, they have also admitted that at the time of general elections.
What are you doing, by the way?
Madam,
what are you are a politician?
Businessman.
Business.
Yes, man, business.
Are you concentrating on business?
Yes.
Also at the time of general elections.
Better.
Next. Okay, so I know.
Date my lord. Judgment is there. My lord, 15
2 weeks. Let the investigation be complete. You know, you will never know that they may require for sending it to ballistic expert.
So I'll
or something think they may, you know, they want.
I don't know record lordship. I'll produce before the authority. But I want to observe.
Once it is released, it will be tempered. So that's the way I want to know.
Yes, sir.
Yes.
36.
36.
My lords.
Yes,
Mr. My lords.
Yes.
3 years. 3 years.
3 years.
Appeal to the bail lords.
Okay.
Four other appeals have been admitted by your lordship. I have given the numbers.
Numbers, huh?
And all the appeals are released on bail matters.
Yes.
Bail and free copy.
Yes, done.
Problem.
I mean, 37. Modification or? 76. What is the problem there?
Adopted instead of peaks 11, that has been inadvertently mentioned high 11.
611 to 511. Yes, for the one?
70.
Madam, naam de.
So Apollo items
Oblige.
39. No, it's happened. First,
One minute.
interview after the assessment.
Yes, sorry.
Item 39.
Yes.
I only papers will call tomorrow.
Mr. Kodkar, tomorrow may not be possible, I tell you. 38.
39.
What is this matter?
That is what for distribution has rejected.
Discharge. No urgency, you can hear. Next week. Next week. Next week, you know.
In item 39, same item 39 votes.
39.
8 October 2020 for claiming of charge. Charge being a normal, I will also take it.
Next week, I'm putting it next week. You get your second. Yes.
Item 61, madam.
61, sir.
Both the party filing affidavit.
One is 61.
Yes.
What is this matter, Jibo?
That way, 498.
Okay. Why you bring them to tomorrow day after you Okay. After 2 weeks.
62 man. The orders notice to OP number 2. They have not appeared. And next week may be taken up. I am perfect.
Notice on opposite party number 2 is not sufficient. 62. Press test to everything.
No, notice sufficient.
The notice written from opposite party in this regard. Total tagging report indicates that item delivered. Item delivered. Item already delivered. Wait, let us see somebody will come. I'll examine it, but wait, somebody may appear, therefore. Yes. Yes.
Lordship, item number 37, I'm praying for 1 week after.
37.
Yes, sir.
37. Not this matter is that vigilance inspector Millards become a party in a particular fraud case. Not
He's coming against discharge.
against the discharge. It come tomorrow.
Lordship, 1 week after.
Not 1 week. If the fresh matters, then it will go to February. I can't accommodate in between. Let it go to February. February.
Let's see item number 67. Let's say matter is compromised.
Anybody is waiting. First thing. Go by signal. Yes. Nice.
42.
42.
Yes.
Yes.
Here, man has to take instruction. This is non-execution of the nothing like that.
I'll pass appropriate order. No, what is don't get better, I'll pass appropriate. No, no. You may not come. I'll do your job.
That's the domestic violence case. I'll
pass a balance order, don't worry.
it's required execution. Order.
You are seeking execution or he is asking for cancellation?
Nobody is seeking.
You are asking for execution.
Execution. That is the order. Time and again. DW, thereafter NBW. Get some instruction. Only instruction might.
We will take the instruction from ILC Douglas report.
That's what I am saying.
5 and 6, my lord.
Why it is not executed?
Yes, ma'am.
But I tell you, we are following the procedure now. Administrative side also, we are following the procedure and interactions are being taking place with the superintendent of police and all, trying to execute all the interviews.
I think for intervention seeking instruction will inure to my benefit.
I'll give a direction to execute.
Yes, ma'am.
I'll give a direction. I'll dispose it.
Yes, my lord.
I'll give a direction, reasonable time, you just speak to them.
Yeah.
What is the reasonable time you tell so that you finish it up. Okay. I'll pass the order. I'll pass the order.
Yes. Item number 67.
60.
Let's say the matter is compromised. Both the parties are present. Maybe
I'll take it up at 2 o'clock. Yes. Yes, sir. Any mentioning?
Item 81 in opposite party. Stay
Shall I grant stay? That's what you want. I'll do. Be ready. We'll dispose it up 2019 to 17. We'll see. We'll see. I'll make some news. 69.
Matrimonial notice has been solved or but not 7 days time.
Item delivered. Already item delivered. Wait. Somebody may come. Let it come at its turn. Okay. No, wait. Somebody may come. You have a petition, no?
Yes.
Wait, let us see. I'll accommodate you, but let us wait. Somebody may come. Okay.
Time. If your lordship could fix it to Monday, 3:30 p.m. my lord,
timing is very difficult. Timing I can't give, but I can. Friday 82?
82 my lord. Friday or Monday my lord.
1 minute. 82. Okay. 2019 matter.
Top of the list if your lordship.
Monday.
Top of the list if your lordship.
I'll take it up. Even today I could have taken it.
My lord, the same thing my lord. Bulky file new lawyer.
Okay. Yes, here. Yes. Yes, sir. Want to mention something?
No. I have a mapping.
Your lordship, item number 73, your lordship. In that matter, please, SK Das and Associates had entered appearance on 20th December 2020. But the name is not reflected neither on the order sheet nor on the cause.
These are matters of 2018.
Yes, your lordship. This if
Next week, huh? Name of so and so. 73.
73.
Name of so and so are reflected. Got this. Yes.
Kindly a short accommodation may be given.
Yes, next week.
Please.
He will just adjust and give. Yes. Yes. Yes.
Item 5.
Yes. 5. Yes.
Those item 5 and 6 relate to the same cause of action. The petitioners, one in this particular case, there is one petitioner. In the second case, there are two petitioners. Well, there is one Tyagi who was the floor manager of the factory of Bhushan Steel situated at Dhenkanal. And there is one Atulya Verma, who was the DGM in charge of the entire factory of Bhushan Steel, my lords, in Dhenkanal. Now, what happens, my lords? They had one furnace, they wanted a second furnace. Second furnace, the work was handed over to a consortium comprising of Larsen and Toubro and a French company, my lords, Polworth. Now, under the scope of work, I have annexed the document which shows the scope of work. They are to handle the entire, if your lordship kindly turns to page 152.
152.
Yes, my lords.
Yes.
Lordship gets it?
Yes.
This is on the this is the contract between Bhushan Steel and Polworth, 152. If your lordship sees clause 3, manufacture, quality assurance, inspection, testing and supply of plant and equipment, except for ones under, then 4, handling at site, then 9, testing after erection and cold trial, commissioning and blow-in, ramp-up, stabilization and carrying out performance guarantee tests of the work. Then, my lords, if your lordship turns to the next page.
What's supposed to carry out this thing?
The consortium comprising of Polworth and Larsen and Toubro. Now, what happens, my lords, after the plant is erected? My lords, this molten steel comes out of the passage, my lords.
At the stage of commissioning.
At the stage of commissioning. Now, once it comes out of the passage, it has to be totally dry, but there was some amount of water for which there was a blast and some people died. Now, my lords, Polworth, because there would be an international incident, and your lordship is aware international, all these diplomacy is involved and other things, my lord, their officers were allowed to leave the spot. It was their responsibility to erect, commission, train the personnel and take steps after the commissioning has been done. What happens? These two persons who were never there, because at that point of time the factory was closed, who were never there, they have been made the scapegoats and proceedings have been initiated against them.
What are the offences?
The offences are
7A.
7A.
92 of the Factories Act.
92 of the Factories Act, my lords. 62B of the Factories Act, 782C of Factories Act, 782B of Factories. You are the occupier. Once I was the occupier, but once I have allowed the commissioning to take place by a different company, at that point of time, they become the occupier.
No, 92, just see, 92 says that the occupier is responsible.
Not the, my lords, but once the scope of work extends to commissioning, to my lords, for my lords, for testing after erection, and there an accident takes place, then my lords, how am I responsible?
That was not yet a part of the factory.
And that was yet not a part of the factory.
Because no manufacturing
process was taking place in that area. So until and unless it becomes a part of the factory, I cannot be attributed the post of the responsibility of an occupier unless and until this portion becomes a part of the factory. There was no manufacturing activity there. We had taken additional land.
See, here 92 is against the occupier and the manager.
Yes, sir.
See, you are the occupier, undoubtedly. You have let out a part of the work to be commissioned by outsourcing companies.
No, my lords. We had acquired a separate additional area for erection of a second blast furnace which was let out.
Who is the owner of the blast furnace?
Blast furnace, my lords, ultimately.
So that means you are the occupier.
the owner.
So now
The commissioning, my lords. Suppose they would not commission the blast furnace, my lords, I'm nothing. So until and unless the blast furnace is commissioned and is brought within the purview of the factory, my lords, how am I responsible as an occupier, my lords?
that is a different story. 92 is directly attracted insofar as you are concerned. And if they have not done any contractual violation has been done, you can proceed against them separately. That's a different story altogether. You can prosecute them, you can ask for recovery, whatever you want to do, you prosecute the remedy under the contract.
Yes, sir.
But in so far as the offence where the death has taken place, you being the occupier, under 92 you are responsible.
My lord, unless and until it becomes a part of the factory. For example, my lords, let us say the High Court is being extended and lands have been acquired.
Come under the factory, then come to the definition.
Yes, sir.
Come to
Factory
the
is
yes. M, 2M. 2M1. Yes. Factory means any premises, including the precinct, whereof
Malazar, just get. I think I misplaced the book.
yes. M2M.
Factory means any premises including the presence thereof where 10 or more workers are working or were working on any day of the preceding 12 months and in any part of which a manufacturing process is being carried on with the aid of the power or is so ordinarily carried on. Whereas 20 or more workers, my lords, here 10 or more workers were never working.
10 were working, but no manufacturing.
And no manufacturing process because this has
Manufacturing
and
process
in
is
any part of which a manufacturing process is being carried on.
Yes.
So, my lords, manufacturing process is not being carried on.
Yes, next, number 2.
Number 2 is wherein 20 or more workers are working or were working on any day of the preceding 12 months and any part in which a manufacturing process is being carried on without the aid of power or is so ordinarily so carried on. So one means manufacturing process means if your lordship sees K, making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing or otherwise treating or adapting any article of substance with a view.
Yes, yes, what you say, because what he says is since it is not commissioned, so therefore it is not a factory. That's what his case is.
But your lordship manufacturing process will be
No, manufacturing has yet to take place. It is a commissioning stage. If a commissioning stage, what is his case is at a commissioning stage, if an accident takes place, since it is not engaged in manufacturing, so it doesn't come under the definition of factory. If it doesn't come under the definition of factory, 92 doesn't attack. This is what his case is. Yes.
But I see manufacturing process. What is the manufacturing process? That is K.
Yes.
Any process of making
K.
Making alternative. So he is making for another project there, madam.
For its use sale.
Let out to another agency model. But he is making the
last time with a view to its use, sale, transport, delivery, or disposal.
Malans, your lordship may see the last line with a view to its use, sale, transport, delivery, or disposal.
Then
it becomes a manufacturing process.
Yes, it needs deliberation. K and M. K and M. Whether it is a factory, when commissioning has not taken place. And issue notice. Okay, issue notice.
Pleasure.
And after 2 weeks. Both the matter. Both the same?
One is under the Factories Act. One is under the PS. It's a police case. 101707 is under a police case, my lords.
Same cause of action.
Same cause of action.
Factories Act instituted and police case also.
Here, what are the offences here?
Under 1707,
How would you get out of it? IPC offense.
IPC offense.
If you can get out of 92, no problem. IPC offense.
IPC offense, my lords. IPC offense, my lords, unless and until it becomes a
304, 34.
34.
333.
I'll reply to your lordship. I'll show you your lordship.
And you 92, I will pass it, no problem. But you will face it.
My lords, I will also satisfy your lordship that this is not made out, because if they don't come within the purview of factory, if it is at a commissioning stage.
No, factory 92, you can.
Not only 92. If I am not responsible for the commissioning of the projects, how can 34 be attracted when I am not responsible? My lords, when I have given it to an agency, there is an international agreement.
Who are the accused here in this matter?
Only
FIR.
in the FIR management of BSL plant.
Yes, madam, he has let out another person, but the.
No, there is an agreement.
FIR is very difficult for you. There, I think you may come out. But
Your lordship, examine
how many people died?
Three.
Have you paid compensation?
Yes.
Where is that? Where have you said that?
We will produce those.
You produce this?
Yes.
Under Factories Act, who has paid?
I guess.
Being occupied, you have paid.
We have paid expression.
Management has paid.
Management has paid expression.
You bring
Huge strike and other things.
I'll just issue notice. Issue notice, let us see. Okay. Yes. Yes. 9. Yes.
Lordships are keeping it after 2 weeks, months.
After 2 weeks.
Because he'll not be here, so that is.
No, 2 weeks after.
Till that date, may I pray for interim stay?
Nothing is going to, it's a very nascent stage. Nothing is. Yes.
Obliged.
At item 9, my lord, I have already served the 161 statements copy to.
Yes. Yes.
My lord, my case is just fairly covered by your lordship's judgment, my lord. May I take your lordship to the 161 statements, my lord?
Let us come to the charge sheet. What are the allegations against you? Let us understand that.
Yes, ma'am.
What are the allegations against you? Under the aid of 109, you have been implicated.
Yes, ma'am.
Let us see what are the allegations against you. Yes. Yes.
My lord, may kindly see page number 74, ma'am.
Yes, 74.
Yes.
Yes.
74, my lord.
Yes.
Somewhere in the bottom, my lord. That during the investigation of this case, it was ascertained by documentary and oral evidence that accused Sri Satyanarayan Sahu, so and so, Bhubaneswar being a public servant, so and so, from his all known source of income and income of his family members. His wife, Srimati Sushma Sahu, is a housewife, having no independent source of income, my lord. But she has assisted her husband, servant Sri Satyanarayan Sahu, in possession, acquisition of following movable assets in her name out of his ill monument.
Okay.
Assets in the name of Srimati Sushma Sahu against her nil income from independent sources described below, my lord. My lord, one flat bearing number 402 and another studio apartment in Puri, my lord, and certain gold ornaments and household articles, my lord. Well, this is the allegation. Merely because
you don't have an independent account.
No, no.
Income.
Yes, ma'am.
And you are not filing return and anything.
No.
Yes.
Not in the check period, we have not filed any IT return.
Yes.
My lord.
Statement.
Yes, ma'am. My lord, 161 statement of Sri Satyanarayan Sahu, my lord, the prime accused was.
Have you seen it? Yes, read it. He's given in the morning.
See, petitioner statement upon. Petitioner statement upon.
Yes. Come to your 161 statement.
Yes, yes.
You are in 161 statement is Kusuma, no? You are Kusuma. Yes. Second paragraph. Read it. I have completed my graduation in economics and arts and so on, so on, class also. Here's my.
My lord, Susuma Sahu, my lord. Statement of Srimati Susuma Sahu, it's in the second.
As I am reading it.
Yes, ma'am. My lord, I was married to Sri Satyanarayan Sahu on 16/2/1987. At the time of my marriage, my father had gifted me.
That studio apartment is one of the.
Studio apartment has been purchased. Now she's putting forth her defense. She is saying that the studio apartment
purchased after selling the land which was given to me during marriage.
It is to be tested.
Yes.
Next, last para.
My husband.
Husband has purchased one flat so and so upon the residency service where Bhubaneswar, situated over plot number so and jointly in my name and in the name of my husband, Satyanarayan Sahu, by taking home loan from the Bhubaneswar jointly in my name and the name of the. So she has knowledge about acquisition of the immovable property. There, the moment knowledge comes, if the intentional aid comes. So there are things as well, madam.
My lord, she has stated in her 161 statement that my father had gifted me about 1,500 square foot of land at Berhampur town. Then she said, my lord, that land was sold about 2 years back and purchased.
Now it has to be proved that your father has given.
No, my lord.
How
He
he
is
prove
not
it?
saying out of that money, my lord, she has purchased this studio flat. my lord.
Yes.
But she is not saying that. My lord, later on, my lord, she is saying like my
This
husband.
land was 2 years back, it was sold. From the sale proceeds, I have purchased it.
My lord, there is no incriminating material. There is no material in this.
It is modern life.
You are trying to justify the acquisition of the assets by your husband.
No, my lord.
By saying that it was flowing from the gift given by my father, blah, blah. You may not have any separate income. But it is not your case that I don't know anything, it is my husband who has done it.
No, my
That's
lord,
not your case.
My lord, I have not defended myself in my 161 statements, my lord. My lord, may kindly see the statement of the husband, my lord. My lord, the second page, my lord. My lord, the third paragraph, my lord.
Yes.
I have also purchased one flat. I have purchased, my lord. Flat number 402 in Aparna Residency, so Sailastri Bihar, situated jointly in my name and in the name of my wife, Susuma Sahu. Right, sale deed number so and so. My lord, in the second subsequent paragraph, my lord, I have also purchased one studio apartment. I have purchased, my lord, not with the money of my wife or anything else. He is saying,
I don't think. It's a co-accused statement anyway.
Yes, sir. My lord, in the absence of the prime accused person, my lord, how can we prove, my lord?
Yes.
That she has abetted or something. When she is saying, my lord, in the third page, my lord, somewhere in the bottom, my lord, the agreement to he has taken 9 lakhs from another person towards sale of that 402 flat at Sailastri Bihar, my lord. He is saying the agreement was kept by Sri Gopundas. I had not kept the copy of this agreement. The cash of rupees 9 lakhs was kept at my home, plot number so and so. My wife was having no knowledge about the execution.
Anyway, but 161 statement, I can't, look into the veracity of those. I got it. I just wanted to know what is the exact fact. 161 statement who is for a accused, prime accused.
Yes.
I'm not going to appreciate what is the evidential value, whatever. On that basis, you can't derive your defense. What else? Yes.
In aid of section 107, I have been added as an accused. My lord, I am squarely covered by the judgment of your lordship. Because in that case, my lord, the ratio which my lord had laid down, that the husband being in a dominant position, my lord, if certain properties are acquired in the name of the wife, or if for that matter, certain properties are acquired in the name of certain relatives, that itself would not constitute an offense under section 107.
107, then it comes because whether if the wife is a very educated person, economy, and thereafter he tries to justify the acquisition of the asset by the husband.
If your lordship would see the 161 statement of the wife, and if the husband's statement is read with that, my lord, it is evident, my lord, which has been also submitted to the charge sheet, that I do not have any independent source of income. And my lord, the asset which has been purchased, it has been purchased by the husband in my name. all that he says that person who gave it to live by a father, thereafter this property was bought. So, but husband says in his 161 statement that I have.
Then I have to like that. I have to appreciate the 161 statement of both of them and discharge you at this stage. That's what you say.
But if I
Can I do that?
But
In 482,
no, but it's with great respect, my lord, so far as your lordship judgment is concerned, there also my lordship relied on the 161 statement of the wife to come to a conclusion.
There he has only said that I have nothing to do with this.
Yes, my lord. So therefore, my lord, over here.
But you are trying to justify. Your
lordship may kindly see. Your lordship may 161 statement. Yes. Lordship, I'll just read out 161 statement of the wife once again, my lord. Your lordship may kindly see the last paragraph.
Yes.
My husband has purchased one flat number 402 in Aparna Residency, Sailashri Vihar, Chandrasekhar Road, Bhubaneswar, situated in plot number so and so, jointly in my name and in the name of my husband, Shri Satyanarayan Sau, White Singly number so and so, by taking loan. Thereafter, my husband can say the details of deposits made in the name at different banks. But I am totally denying. My difference is that I am, and even during investigation, they have come to a conclusion that I do not have an independent source of income. In the charge sheet, it is apparent.
Despite you having no independent income,
yes,
you are trying to justify. It's coming from my father. My father had given a property. I sold it. All the story you are telling.
Over there, only one.
Then you are trying to see your husband. And wrongly. That is the reason 107.
My husband has been charged with disproportionate assets to the tune of near about 1 crore 8 lakhs, my lord. Now, my lord, there are so many properties which have been shown to be his properties, his ill-gotten money. But now in his absence, the
discharge application is rejected.
I have not filed any discharge application. It shorts my conscience, my lord. How in the absence
this is
be held later.
This is cognigency.
Right now, my lord, the police papers have been just supplied to us. That's all.
You go and argue that before this thing. Right. Well, what are you saying? That is even though there is no direct material and the petitioner requested the husband to purchase the property in her name out of his own ill-gotten money. The fact that that's right. That's right. That's the problem. That's the 161 statement. That's the problem.
And the perspective, if a lordship will find, prior to
don't see the problem.
Indian tax returns was also
the problem is the husband has died. Okay. You then you can't prove anything against husband. Husband is gone, everything.
I can't be possible to explain.
And only wife is there. Let him argue at the stage of charge and all these things.
That is separate.
And she may be discharged also because evidence may not be sufficient to frame charge.
সেটা তো আলাদা কথা কিন্তু thing is that even if husband
give an opportunity thereafter at least he can
there is no exact formula by not if the husband dies even the abettor also
move the petitioner and argue. Petitioner is one of the accused along with her late husband. In vigilance VA's case number, which vigilance case? Vigilance cell. Case number 3 of 4 2015. After investigation, charge sheet has been filed in the present case on 31/3/2021. When the principal accused died? During investigation or after?
No. After submission of the charge sheet.
After the submission of charge sheet report, the charge was framed against the petitioner. The principal accused, then mainly the husband of the present petitioner, has expired. At this stage, the petitioner has approached this court by filing the present petition, seeking quashing of the entire criminal prosecution on the ground that the principal accused has already expired, and taking the allegation made in the charge sheet at its face value, no case is made out. Mr. Hon'Ble and counsel for the vigilance submits that the petitioner has been a petitioner is sought to be prosecuted along with the late husband of the late husband who is the principal accused under the aid of 109 IPC. The petitioner has put forth or independent specific defense trying to explain the asset acquired by the by her husband, which is stated to be disproportionate to the known source of income. Known source of income. Mr. Rai, learned counsel for the petitioner, has relied upon the judgment of this court in what is that? And submit that the case of the present petition is squarely covered by the judgment of this court. At this stage, I'm not at this stage, I'm not inclined to entertain this petition and dwell upon the merits of the case. Rather, it is expedient on the part of the petitioner to move appropriate application before the trial court and agitate all the issues before the trial court. If such application is moved, some shall be considered on its merits. With these observations, the petition
Seeking discharge, my lord. Application seeking discharge.
Application seeking discharge. You argue all the point. You may discuss.
The trial court would say his lordship could have very.
It is made clear that the fact that this court has not expressed any opinion on the merits of the case. I am not expressing. Yes. 18. Yes. I mean, Mrs. Tripathi, you have done a good job. Okay. 18. Nobody appears.
Pending of civil dispute, present petition with the son and wife, astrological number of old age parents.
Son and
wife. Astrological father and mother.
Parents who?
Again.
Petitioners are seeking quashing of the convenience has been taken. Quashing of the order dated 11/6/2021 passed by the JMFC Cuttack in GR case number 382 of 2021, whereby the cognizance of offences punishable under section
341, 23, 294, 506, 34
IPC has been taken against him. The petitioners are the son and the daughter-in-law of the informant of the informant and the victim. Informant of the victim. The perusal of the allegation made in the charge sheet and the statement of the victim and informant under 161 CRPC reveals a clear case. Makes out clear case against the petitioner. Therefore, the trial court has rightly taken cognizance of offences punishable under section so and so against the petitioner. Hence, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to raise all the points before the trial court at appropriate stage. Yes, next.
26.
Lordship, I am challenging the implement order, expert implement order.
Yes.
The decision Rayanpur. Subsequently confirmed the reference of Rayanpur.
What is the order of maintenance? How much is the order?
15,000 rupees.
Yes.
Implement order. Actually, he was fixed on the order. Basing upon the affidavit of the affidavit party. I was not given opportunity to asset statement. And
Near the point.
Yes.
Paragraph 12. The
Yes.
appellate
Yes.
considering the contention of the current counsel of the appellant. It is pertinent to note here that the contention raised by the appellant here the petitioner. They have not subject to acute respondent domestic violence are matter to be decided during trial after evidence is taken both sides. At this stage, it is essential to note that in fact appellant and the respondent being husband and the wife
They are living in shared household and we are in a domestic relationship since their marriage till 2022. The active respondent had also launched report against the applicant.
What are you doing? Your worship friend, I have just one Bolero vehicle, I have given in rent and I am earning only 5,000 rupees per month. After paying driver's salary and
You have a driver. Money to pay to your wife.
no, only Bolero I am earning a Bolero, which is only income. Because they only stayed for 15 years. Actually, the marriage and children in the 22. And she left the house on 1622. After 22 years. And the third party, she was also earning 15,000 per month. She is a nurse. She is working as a nurse in the government hospital on contractual basis. Her income is 15,000. My income is 5,000.
What is matter? Which entry maintenance only?
No, 15,000 is much I cannot pay the amount because I have taken a second-hand Bolero. My income is only with the account.
I think area now.
The order is passed.
Area.
Last May 2024, the High Court passed the order.
But
you have not paid a single rupee.
I have not paid anything.
See, then areas must be. When she moved the application?
I have to pay such a big amount, 60,000 rupees now. I can pay 10,000 rupees per year. I cannot pay year for first night my university already 5 months. Today it comes around 75,000 rupees. I cannot pay such a big amount.
Issue notice after 4 weeks, the same thing will happen. If the area will be accumulating to lakhs of.
No, that will be good. But I am given
no law involved in this thing.
I am given
Law involved in this. Simply you have to pay Neha, what is that? Rajesh Neha. Judgment Supreme Court is directly there.
Yes,
On the basis of affidavit, it is decided what to do.
Yeah, I will give an affidavit regarding my asset statement if I am given an opportunity. And I am ready to pay a year, but not 5,000 rupees, 15,000
You do one thing. Subject to you making the entire making good the entire areas of rent, areas of maintenance. I will allow you to move application, file an affidavit as and it will be
25% subject to amount.
Maintenance matter, no interest.
My income is only 5,000 euros.
Income after marriage.
Her income is 15,000. She is earning more than me.
He is a housewife.
Petitioner is aided by the order dated 17/8/2024 passed by Additional Sessions Judge Rairangpur in criminal appeal number 6 of 2024, whereby the petitioner is directed to pay interim maintenance at the rate of 15,000 rupees per month to the opposite party. The opposite party, the court of SDJM Rairangpur by its order dated 5/1/5/2024 in CMC number 40 of 2024 had directed the petitioner to pay the interim maintenance at the rate of 15,000 per month. Agreed by the said order, the petitioner filed the revision petition before the Court of Additional Sessions Judge Rairangpur in revision appeal in criminal appeal number 6 of 2024. By the impugn order, the appeal has been rejected. I peruse the impugn order. The impugn order is a detailed order giving all reasons confirm all regions to confirm the order of the trial court. The appellate court has also appellate court in the interim order has also taken note of the judgment of the Honorable Supreme Court in reported in 2021 to ACC 324 Rajesh versus Neha. The law regarding the interim maintenance law regarding the calculation of interim maintenance pending the final disposal of the maintenance petition is well established, and there is no res integra in the there is no well established as per the principle laid down by the Supreme Court in Rajesh versus Rajesh Supra, Rajesh Supra. Therefore, no interference is called for at this stage. However, the petitioner is given liberty to move application before the trial court for variance of the interim order, subject to the petitioner making good all the areas as of today. If the petitioner make good the areas of interim maintenance, in that case, the application to be moved by the petitioner for variance of the order may be.
Opportunity would be three instruments. At once, I cannot be ready.
And counsel for the petitioner submits that owing to the financial health of the present petitioner, he is not capable of paying the areas of maintenance, areas of interim maintenance in one go. Hence, he may be allowed to make good the payment on installment basis. If in installment basis, the petitioner is granted liberty to make such prayer before the trial court at the time of hearing of his application for variance. Yes.
Right.
31. Yes.
Already joined.
Yes, madam. Where are you? Where is your client?
Already joined to VC, madam.
Where are they?
In the first director.
Manisha Priyadarsini.
Manisha Priyadarsini and
Himanshu Shekhar. They are not doing item 55, no? 31. Not doing. Ask them to join.
My lord, I already instructed him to join by 3.
You go outside and ask them to join. When if they join, you tell me. We can take it up. Okay. Ask, call them, both of you. Yes.
67.
67. Yes.
Last provision was directed to issue a notice. I filed the notice after the receipt of notice. My friend has been before the honorable court for the informal lordship. The matter has been settled. Both the parties are present before this honorable court lordship.
Where are they?
They are outside.
What are the offense?
323, 354, 379, 292, 506.
Charge sheet has been filed.
Charge sheet has been not filed, lordship.
Not filed.
And both the parties, given undertaking before the police. I have annexed 2, lordship. Kindly see page 13, lordship.
Yes. What they have said?
And now both are settled and
what they have said, what are the terms of settlement, what are the allegations?
The allegation there, both have belongs to one family lordship. And out of civil dispute, the case has been initiated against the petitioners.
Who are they?
But may I please the FIR?
No, it's all right. Minor offenses. Yes. Kailash Chandra Purida. Minati. Minati, Nikita, Sujata, Liability. Okay, right down. At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. The allegation against the petitioner, para 2 of the petition. The all the petitioners, tell them to go out, all of them. Tell them to go out. Here, all the petitioners and the opposite party number 2 are present in the court, being represented by their respective counsel and identified by them. They've also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken under court. When the matter is at the investigation, the matter is at the investigation stage. At that stage, the parties have settled their dispute and filed an affidavit. What is this affidavit before affidavit?
Yes, sir.
For the wrote a letter. This is a letter. Wrote a letter to the IAC of which police station? Khurda police station. IAC Khurda police station. Interior stating that they have settled their dispute and requested the IAC not to proceed with the matter anymore. When when the said letter was not paid any heed by the investigating officer, they have approached this court seeking quashing of the FIR on the ground of settlement. The parties have filed the opposite party number 2 has filed a affidavit dated 20th November so inter alia stating as under. कुछ भी नहीं लिखते हैं 2, 3, 4 complete. 2, 3, 4. On queries from the court, opposite party number 2 has reiterated her stayed and stated that due to intervention with the elders in the family and the village entries, she has settled the dispute and doesn't want to proceed against the petitioner. Mr. Tej Pratap appears for the state and submits that since the allegations are minor in nature and parties have settled the dispute, there is no legal impediment in quashing the FIR. Hence, indulgence by this court can be given at this stage. Regarding head to the nature of allegation and the fact that the parties have settled the dispute and filed affidavit in that regard. I am for the considered view that in the case of the present petitions are squarely covered by the judgment of the Honorable Supreme Court in Gyanchand, Madhav Rao and P.S. Joshi. Hence, subjecting the petitioner to the rigors of the trial would be a futile exercise. Accordingly, the FIR number so and so and consequential proceeding arising therefrom or the present petitions are passed. So and so enters appearance for opposite party or notice and files now which is taken on record. Yes. Next. 38. Then once they come board, they're not joined. They're not joined. It's not just check it up. Whether the parties have joined? Not joined. Yes. Ask them to join properly. Yes.
No, please, my lord.
Before my learned friends start, submit your lordship notes. The main thrust of my learned friends petitioner's grants contention is that we are let off in the deputy. That's why we should have been discharged, my lords. The similar issue, my lords, a lordship posted in similar matters on 25th, my lords. But this case may not be tagged with that, my lords.
Which one?
25th.
25th.
20th October. So those matters because we are let off in a deputy proceeding.
And we have the numbers.
I've given all the numbers.
Yes. Yes. Please on 25th. Okay. Yes.
Limited 12 words. Matter is posted to on 6 December for filing of charge.
Then what will happen? That you ask for. Yes.
Lordship may just remember
Interim order, I know what is happening in the interim order in this court.
your Lordship may not pass an interim stay, my lord. Lordship may reflect that if I move an application seeking adjournment, the same shall be considered.
Yes, move application, let him move application. Yes.
40.
That's okay.
My lord, I am appearing on behalf of Mr. Jugal Kishore Panda.
In this case, Lord, my friend Mr. Panda has also requested me to adjourn for next week, lords. Yes, unfortunately.
She can argue. Okay, at request, sir.
Next week, lords.
Yes, he will give it.
This is the matter, lords, post abused, and subsequently he was in a different post, my lord. In the meantime, cognizance order was taken. That Supreme Court stands on.
Whether if you have shown me a judgment, direct judgment, yes. You have a difficult case. See, shown directly covered by a judgment. If you are in a particular post, you are there. You abuse that post as a result of which some case is registered. And by the time cognizance is taken, you are no in that post. You have been transferred or you have been demoted to another post. Then in that case, sanction is not required. That's what the judgment is. You have to deal with the judgment. Take the judgment to, from sir and read contrary judgment if you can show. Very good.
His senior has been provided with copy, lords.
Give her. She will.
Take
it from sir. Take it. Yes.
41.
Wait, please. Here also, could I go to me? Here also, lords, the interim order indicates at page 43, lords, that the case was last posted on 16th September 2024 for pending of charge.
But the peculiarity of the case is, this case dates back to Violent Kailisi Annexure 1, 2003. Yes. But before I am drawing minus attention to the papers.
You have no application for discharge, which is
yes. But let me say, Ballot. Here, Ballot, for a construction of a bridge from Baripada to Jharkhand, around 8 kilometers, authorities have divided the same into five sections. So for 5 sections, 5 contractors were appointed or engaged, and persons like petitioner, who was an engineer there, acute engineer, chief engineers were also directed to take charge of the construction. Construction was completed during due time, because it was badly necessary during that period. But investigation but after the completion of the work, so much of vigilance, they initiated a proceeding and they say that some extra amount has been paid to the contractors. However, after conclusion of the investigation, final report was submitted. Pilot may kindly see the final report. Finally, for 5 works, 5 cases have been registered. VGR 22, this present case VGR 29, 30, 31, 32.
5 cases or 5 pages?
Yes.
Pages of work, my lord, within that 8 kilometers.
My lord.
Yes.
My lord, here
you are accused in all the 5 cases.
No, in 3 cases. My lord may see page 66 of the brief.
Yes.
6/7/2007. Order serial number 21, 6/7/2007.
Yes.
Final FRT number 15, that is so and so has been submitted. Page 66.
Yes. Yes.
Let me see.
FRT number 15.
Pilot. After that, let me see why I am drawing my attention to this. Page 67.
No, before that, FF not received, what is this?
Final form.
No, FF not received.
Final form has not been received. It was not either
final form they found.
Either charge sheet or final
form, yes.
So charge sheet could not be submitted. Rather, they suggested in the charge sheet to go for departmental inquiry. On 6/7/2007, they ultimately submitted final report. Final report then no case is there, no criminal negligence is there. So engineers ballot, the persons like Prabhat Mishra, who is now 91 years old. He ballot case was construction of the year 93. FIR was lodged in the year 2003. Charge sheet was submitted in the final report was submitted in 2007. Why I am saying the dates? After that, my let me see. Base 67.
Yes.
Serial number 22. But a direction was given by the seizure, sorry, by the then special judge vigilance.
No protest petition is filed. It's notice to the complainant.
Complainant is IO. But how application of mind by the special judge, ballot may kindly see after that. How many occasions case has been adjourned for filing of protest petition? That I want to draw my answer. Serial number 22, 23, 24, 25, 26.
It goes on and on.
On and on.
Yes.
Ballot.
Up to 70, page 70.
Ballot.
Complainant has filed
no, ballot. Rising out of slumber ballot, say by order number serial number 34, the complainant has not filed any protest petition as yet. Put up so and so for filed protest petition. If
then the
complainant has not filed any protest petition.
Tenure of the order is changed. Now they say complainant has not filed protest petition. Went out.
In that process, it continued.
No protest petition.
In that process, informant is absent, notice to the informant is not back. Like that, whether it continued till page.
Then 73 issues summons to the informant. Yes, Mr. Das. What is this?
Page 81, 82.
The similar sins are there.
60 occasions case was adjourned.
What will you get out of it?
Let me complete. But here in this same manner, in one case, VGR 37, the same special judge vigilance, Baleshwar, what he did, what he did, he accepted the final report and closed the case. Here, my lord, in other 4 cases, same IO, same FRT, everything is same. Accused persons were also same. Only the contractor was different, otherwise this engineer said. That case was closed. FRT was accepted.
All 4 cases?
No. In VGR 37. 35. Ballot. It was closed. And FRT was accepted. Case was closed and no notice to any accused persons. Here, ballot, out of ballot, say from 2006 to
now come to 83, page 83.
83 ballot. Say ballot,
what does it do now?
2/9/2017, cognizance was taken by passing an elaborate order which has got to what? On that fact, question crops up, legal question is, vigilance judge who has accepted the final report and directed the complainant to file protest petition, can he go back? Number 1.
Yes, I understood it. Yes.
So in this case, this case is coming for the first time. It's listed for the first time. One second is, all these matters, at least 2-3 matters are clogged up, may get
this matter. It is a process of law.
So far that submission is concerned, that is on record, Lords. I don't dispute at present, I don't have matters with me. You also give me a hearing after 2-3 days, I'll come back to Lords.
I come tomorrow. There is nothing unnecessary. These matters. See, 93 something has happened.
I've gone through the right. I've gone through.
See, the filing form was filed by you. You have filed by FIR. And thereafter, repeated notices were issued to you. Nothing less than 50 times. You didn't go. Thereafter, the same judicial officer, when the judicial officer changed, special judge, on the same material takes the cognizance. How can it be possible? For years, whether it is going on. Just see from where. From where it is from 2013.
It is going on
2013.
since, well, after
2011.
And then it was
2011.
and then it's
2009.
17 lots. I got it.
2007.
It's ending with 17 lots. I got it. But what
From 2007 to 2017. The paper that has been issued notice to the complainant. Who is the complainant? The officer. He doesn't come. And after lapse of 6 years, you take cognizance on the basis of chain material.
Lordship, give me 2-3 days. I'll come back. But there's a case from Baripada, but I'll phone. I'll get it.
Now, read judgment. You say whatever. This is advances.
I Lakshmi, I will give you within 2-3 days. I don't pray for
Okay, Monday. Let him be here. Monday. I don't think you can say anything in this. Nothing to say.
Okay, but they have right to be informed.
Completely non-application.
I have not sent any letter.
I read all these things, Malad, before I personally appeared before the additional, because person concern is 75 years.
And they see the flip side. Even if the cognizance order is mentally, 93 incident had happened. You will not see the principal accused is 93 or something, he said now. And the witnesses will not be there.
Stand is completely bad.
What will you do with this? Yes.
I understand. But may I suggest
Monday?
It's a case from Baripada.
Yes,
No, I agree with the Lordship. Only they have right to be informed. I must send the copy of the petition.
Of course, I understand.
Only the formalities has to be.
Yes. When you want.
Any day next week.
That's what I'm saying.
One day it will be 2 hours.
27, 28, any day?
27th.
27? Okay, 27. Okay.
30. Exactly for the petition along with the NBW issued against opposite party is not yet executed. And the direction is given to IIC, Jagatsinghpur, to page 30, my lordship.
When the NBW was issued?
Yes, my lordship, it was 23rd 8, 2024. 23rd 8, 2024.
When the NBW was issued originally?
The order was on.
Petition is agreed. First, original NBW, you tell me when it was issued.
23rd December 2022.
Yes, 23rd December. Na? The petition is agreed by the order dated 23/8/2024, whereby the following order was passed. Page 30. TC out of the other to Land Counsel for the petitioner, Mr. Mishra, Land Counsel for the petitioner, submits that despite the fact that the NBW against the opposite parties have already been issued on December, which December you say? 23rd December 2023.
Yes, ma'am. 2022.
2022. The same has not yet been executed, as a result of which the trial, the pending trial is getting delayed. Mr. Maharana, appearing for the state, submits that sufficient efforts have been appears to have been taken by the concerned police station for the purpose of execution of the NBW issued against the opposite parties. I'm not inclined to keep for the present petition pending at this stage. Therefore, the same is disposed of with a direction to the IIC. Which the IIC? What is that? Jagatsinghpur IIC to make sure that the NBW issued against the opposite parties by the order dated December 23 December 2022. 2022 is executed without fail within 6 weeks from the date of receipt of the notice. Yes.
43. NBW issued against the petitioner on dated 3/8/24.
38,
2024.
yes,
Earlier than well, 15/3/2024.
15/3/24, NBW on
3/8.
38, 500, yes.
44.
In this application, the petitioner challenges the issuance of Hon'Ble as well as 82, 83 process matter. Someone has not been sufficient matter, warrant has been issued. So tell me when we will do it. Hon'Ble matter 18/5/2017.
So 18/5/2017.
And
82 proceeding?
82 matter 9/2/2021.
And we see 82, what you said?
18/5/2017 warrant matter.
18/5/2017 warrant was issued since
And 9/2/2021.
So proceeding under section 82, 83, CRPC has already been initiated against the petitioner by the order dated
9/2/2021.
9/2. At this stage, the petitioner is seeking quashing of the NBW and the process initiated under section 82, 83 CRPC. Learned counsel over the petitioner submits that he was on bail. The petitioner have been absconding. Hence the NBW was issued. Be that as it may, petitioner, the counsel for the petitioner on instruction from the petitioner submits that the petitioner would surrender public appear before the court below on or before 5th of December and seek remedy available to him under law. Regarding head to the statement made at the bar, the NBW issued against the petitioner by the order dated so and so shall be the execution of NBW issued by so and so shall be kept in abeyance till 5th of December so subject to the petitioner appearing before the court and resorting the remedy available to him under law and paying a cost of rupees 1,000 to the which bar association is that? Where is that district bar association? District bar association. Okay.
Already not appeared before 2003 to.
Equal regulation.
Already not appeared before.
You tell me the installment should be maintained for another 50 years? He's ready to go and appear. Let him go and appear. The due process will take care. If you, I'll reject it. Okay, I'll reject it. Thereafter? After 20 years, again he'll come. Let the law take its own course. Is one. The cost you increase. Yes. You tell me that. Make it 2,000. You have been absconding. So that's someone has been sufficient. 2017. Someone sufficient. You are paying it to bar only. Not paying. Yes, pay. 15,000. DHJ 1,500 करते हैं. Yes. District bar association. Yes. Yes. 45.
Belgium Metro Minor. NBW issued on 29/11/2022.
Yes, bail on 11/3/2022.
Bail on
11/3/2022.
Okay. 500. Yes.
This is one of Belgium Metro. NBW was issued on 29/2022 matter.
Yes.
And bail was on 9/5/2014 matter.
500. Yes.
47.
It is posted on bail 11/10/2006. Our NBW has been issued on 28/8/2024.
How many of you are there?
Pardon me.
500 each. 500 each.
4%.
Four of you are there, not?
My lord, 28/8/24 NBW.
Which police station? Which
Rampur police station.
Rampur.
My lord.
Which district court?
My lord, in the district of
Rampur bar. Leave it to Rampur bar.
No, my lord.
No. Yes.
48.
48 Belgium matter. NBW was issued on 29/2022. Petition was on bail, one was on bail 4/2/2014. 2 and 3 on 7/11/2013.
ठीक है. 500. ये पुरुषोत्तमपुर बार पुरुषोत्तमपुर. Yes.
49.
May please your losses. I'm appearing in virtual mode. Here, initially, case was registered against.
CD is not. CD call for CD. Yes. Next.
May I raise just one thing, my lord. The connected matter is BLAPL number 9201 of 2024, and the matter is before you on 5th December 2020.
5th December. December. Yes.
The
Yes. 50.
May I please, Lordship?
Yes.
Lordship, earlier application dispose of directing the petitioner to renew his prayer. Thereafter, the petitioner renew his prayer and that has been rejected under Annexure 3, my lord.
Yes.
The case is, my lord, under 302. Well, Lordship, kindly see one evidence, my lord, the informant examined.
Yes.
Page 18, my lord, Annexure 4, that is the position, my lord, I have given.
Read. Which part?
Page 18, my lord. My lord, the wife of the informant, my lord, committed suicide, my lord. But there is allegation that the petitioner, my lord, is the person who, my lord, killed the, that is, my lord, your lordship, kindly see para 2, page 19, I am reading of that. The accused has killed my wife. I used to go Hyderabad and the Vijayawada in search of work. During my absence, the accused perhaps had illicit affair with my wife and he might have killed her. But I do not know the reason as to why he killed my wife. I came to know about the illicit relationship as the wife and mother of the accused had told me about it.
Yes.
This is the, my lord, statement, my lord, but she committed the suicide, my lord. And there is no other allegation except, my lord, the circumstances, my lord. There is no eyewitness to the occurrence, my lord.
What are the material?
And the petitioner is in custody.
Yes.
This is not a suicidal case matter because there is strangulation. For which, though initially the case was registered on the section 306, subsequently the case turned to 302. And I am the case based on circumstantial evidence. And there is a last scene theory with this.
Who is the witness to that?
I am relying on the 164 statement of Bandham Darkad Rao. Bandham Darkad Rao.
Prasad Rao.
Bandham Prasad Rao.
Prasad Rao.
ଅଂଶ ଦିଦି ଆମ ଗାଁ ପାଖ ଗାଁ ହମ୍ସାରେ ଭୋଜି ହେଲା ଆମେ ସେଇ ଭୋଜିକୁ ବ୍ୟସ୍ତ ଥିଲି 11ଟା ପର୍ଯ୍ୟନ୍ତ ମୁଁ ସେଇ ଭୋଜିରେ କରିଥିଲି ମୋର ବିର୍ଲା ଗେମୁଣ୍ଡରେ କାମ ଥିଲା ସେଇ 11:30 12ଟା ଦିନ ବେଳେ ଗାର୍ଲା ମୁଣ୍ଡରେ ପାଇଁ ବାହାରିଲି ଏଫସିଆଇ ଗୋଦାମ ମାଣିଗର ପାଖରେ ମୁଁ ଗୋପୀ ପିଟିସନର ଉଷା ରାଣୀକୁ ଦେଖିଲି ସେମାନେ ରାସ୍ତା ଉପରେ ଛିଡା ହୋଇ ପାଟିତୁଣ୍ଡ କରୁଥିଲେ ମୁଁ ଯାଇ ରଖି ତାଙ୍କ ପାଖକୁ ଗଲି ଉଷା କହୁଥିଲା ଗାଁରେ ମୁଁ ତୁ ବେଳେ ଆମ ପାଇଁ ଗଣ୍ଡଗୋଳ ମୁଁ ଭଲରେ ରହିପାରୁନାହିଁ ମତେ କୁଆଡେ ହେଲେ ନେଇଯା
Doctor's evidence. What doctor says?
Postmortem report, my lord. Death was due to asphyxia as a result of constricting force round the neck.
Yes.
Round the neck.
Doctor and this Prasad Rao, we examined. Right up. Petitioner is agreed by the order dated 7/10/2024, whereby bail application has been rejected. Learned counsel for the petitioner has relied upon the testimony of PW1, the informant, and submitted that the informant whose wife was alleged to have been killed by the present petitioner has deposed before the court that he suspect the petitioner has been involved in the present case as the petitioner, his wife was having relationship with the petitioner. Mr. General and counsel for the petitioner on the contrary read out to the statement of one Radha Prasad Rao. Randhava Prasad Rao.
G. Prasad Rao, your lordship.
Prasad Rao. R. Prasad Rao. So under section G. Prasad Rao under section 164 CRPC, and has also read out the evidence of the doctor who inter alia stated that the death is due to death is caused due to
asphyxia, my lord, as the result, consist.
As a result,
The result of constructing force round the neck.
Constructing force round the neck, round the neck.
Caused by possible any soft ligature of
Related to the
material.
nature of the evidence which is form part of the charge sheet. I'm not inclined to enlarge the petition on bail at this stage. However, the petitioner is given liberty to renew the bail plea after the material witnesses, particularly the witnesses whose statement under 164 CRPC is recorded, and the recording of the evidence of the doctors. Yes, with this liberty, the petition is disposed of. Yes, next.
51.
May I please urge?
Yes.
But force evidence this is the second one of the petition, Your Lordship. Will also be liberty granted to after filing of charge sheet to remove the case, my lord.
Yes. Where is charge sheet? You do you have the document?
Yes, my lord.
Huh? Call for case date. Yes. Next.
52.
Hon'Ble, Your Lordship.
Yes.
Your Lordship, the petitioner is a 20-year-old helper of the vehicle, my lord. Helper of the vehicle, my lord. And he is his custody since 24/5/2023, my lord.
24/5/2023. 23.
Yes, my lord.
Yes.
And your last occasion, your lordship had called for the status report, my lord.
Yes. What is the recovery?
257 kg, 800 grams. And he is outside from here.
Out of 12 witnesses, 3 witnesses were examined. No, the dates and so. You are outside.
My lord, from Bihar, my lord.
Bihar.
My lord.
You file an affidavit disclosing your police station where you stay, a particular the police station and phone number of the IIC of the police station.
Within 6 months, if not completed, he can remove. Because
He is already there in custody for more than 1 year.
Yes, my lord. 1 year, 5 months.
Merely because he's outsider, he's a citizen, we can't. But the only thing is you have to ensure his presence. So let him give an affidavit.
My lord.
Disclosing the police station where you district and the phone number of the IOC and the police station phone number. And they will verify if the phone number and everything is correct. Yes. Release it after 2 weeks. File an affidavit. Yes, ma'am. 2 weeks.
53.
On behalf of Mr. Mahathi, my lord, I am permitted to replace my lord.
How many bail applications are there? Yes.
Well, on behalf of Mr. Mahathi, I am placing my lord.
23.
This is the second general litigation, my lord.
Yes.
This is the bail application, the your lordship directed to remove the prayer by the order of 29 to 24.
What are the evidences?
My lord, the evidence is the circumstantial evidence and the last thing theory, my lord. The lordship, one of the last thing theory, the witnesses is Govind Raut, my lord. The lordship, I have annexed page 45, my lord. 45. He is hostile in this case, my lord.
Yes.
And then, my lord, the another witnesses, my lord. What I guess, my lordship, that out of 70.
Yes, Mr. General. Have you seen it? Give a copy. List it after 1 week. Yes. Next.
54.
May I please your lordship? My lord, I am the BC lordship. My lord, may I please your lordship?
Yes, yes.
My lord, offense under section 363, 366, 342, 3762N and 376, 506 and 4 and 6 of POSCO Act, my lord. My lord, it is second bail applications. And my lord, earlier stage, my lord was directed to be submitted the victim deposition, your lordship.
Now,
my lord, kindly
notice head sufficient to super improvement. Victims can send notice head sufficient lordship. But perhaps in the police station.
And today morning I have already directed to appear report the BC through VC report the concerned police station also. Notice here is sufficient, the acknowledgement is here.
The informant.
Yes, sir. Also.
Who is informant?
The informant in this case, the CD is not there in this case also.
Call for CD.
Yes, sir.
And then the notice to informant. Who is the informant?
Informant is lots of his father.
Father.
Yes, sir. Also.
Is in custody since?
Lordship, Lordship, custody since for 24/9/2023.
24/9?
2023.
23. 1 year already.
Yes, Your Lordship.
What is the stage of trial?
Lordship.
Obtained instruction. Stage of the trial up to 2 weeks. Yes. See, 1 year we can't wait. 1 year if you don't do, then I can't bail.
Yes, sir.
Yes.
Last time the test, CD was called for.
CD. You got the CD?
55 also it is not there.
CD, okay.
The married veteran-in-law in custody since 26/8/2024.
What are the offences?
That 492, 306, then 323, 4 DPA, and 306.
306.
I am. Husband in custody. I am the JA.
Lady?
I am.
What will you do? 1 year already.
I have already wrote later lordship is 6, 7, 11.
I don't know. Custody since
26/8/2024.
26/8/2024. 24.
I am.
Oh, 1 year. I thought 23. So call for the CD.
Let's keep it. Next figure we can have.
Yes.
56.
Here is the case 302 or
Yes.
Offense under 302. The FIR was lodged by the father of the deceased. The allegation that his son works as a GRF and he usually goes to the work in the morning and comes to the
also CD is not with me, your lordship, but here is the case earlier present person approach for general.
Call for let 302 let him get the.
ମୁଁ ମନା କରୁନି 7/11 ଆପଣ ସିଡି କଲ୍ ଫର କରିଥିଲେ so let them expedite CD 9 302 can I press that certificate of but they should make an attempt.
Get the CD.
Get the CD.
I am for the informant. In this matter, you are.
I thought you were saying I am the CD. You have papers, give it.
Oh my God, I have only a FIR copy.
Okay. Oh,
But my lord, in this.
I've got this. I've got this.
let him get the CD.
Yes, yes. I've got the certificate copies of all these cases.
Why don't you give him?
They give me a second.
Photocopy you give.
Yes, I've got director. I will have.
You give it, you bring it and that's okay. 1 week up.
One pivotal aspect, my lord.
No, 1 week up.
My lord, what is the change of circumstances, your lordship?
I'll just take it up. Change of circumstances, he is coming. You change the sides. That is the change of circumstances.
Yes, I will charge sheet. Now, consider do something.
Change of circumstances is change of side. By you. That's the change of circumstances. What else you need? Yes.
57.
CD is this.
My lord, this is a second bail application. One of the earlier bail application was disposed of by this Hon'Ble court, granting me opportunity, liberty to approach the lower court pursuant to the filing of charge sheet, wherein the charges under section 302 was converted to section 306. And my lords, this
now charge sheet is filed under 306.
Yes, my lord.
Yes. You are the husband.
No, my lords, brother-in-law.
Brother-in-law.
Yes, my lord.
You custody since?
My lords, 9/3/2024, 9th March 2024.
24. You show me what are the allegations. Let's see.
Yes,
what are the against this gentleman?
Yes, sir. So I am reading the statement of the father of the deceased, your lordship. It is clearly stated the name of present lordship. I am not working.
A father will forget about how he died.
Lordship, cause of
Father will make you any allegation.
with me, your lordship, cause of death, your lordship.
Cause of death. Hanging. Poison. What is that?
Poison, my lords.
The opinion is cause of death is kept pending till receive the chemical report. Chemical report not yet been received by the conviction by Visera, which is duly packed and your lordship, here is the cause. Actually, from the return of the body of the deceased. Your lordship, what happened in this case, your lordship? The present petitioner is the brother-in-law of the deceased, your lordship. Is by regularly torturing and assaulting the present.
What kind of torture? Physical torture?
That's why I am reading one statement. Kindly allow me to read the statement of the.
What kind of thing you unnecessary? Wasting time. Please see tomorrow. Tomorrow I may change my mind. This is how, I don't know, this is how the, you have to be prompt enough.
It's there in the, sorry, my lord, it's there in the petition only.
Except FIR, you have not filed anything, first of all.
My lord,
Still I am giving you license. What kind of petition you are filing?
my lord's page 15.
Huh?
Page 15.
50?
Page 15, 15.
50, item 57? Yes. Page 50.
15, my lords. Minus in here only, it says ki husband can be released on bail.
Where is that? Which portion?
My lord's last page 17.
16 page, your lordship. On basis of the material, the court is find that there is no direct evidence in regard to the actual abetment by the accused husband in the suicide of the deceased is not instigated by the accused husband. That is the page 16, your lordship.
Rejected and
the other hand, the
only rejected and okay. Petitioner is accused in so and so case, along with one along with his brother Sudarshan. Wow, Sudarshan Bank. The allegation against the petitioner in the FIR is so and so. The petitioner is agreed by the order dated 1/10/2024, whereby his bail application has been turned down, whereas his brother's bail application has been allowed. The petitioner is the brother-in-law of the deceased, and the co-accused who has been enlarged on bail by the trial court is the husband of the deceased. Husband of the deceased. Petitioner is already in custody from 9/3/2024. Regarding head to the fact that the co-accused, who is the husband of the deceased, has been enlarged on bail and the petitioner is in custody since 9/3/2024. I am inclined to enlarge the petitioner on bail, admit the petitioner on bail. Accordingly, the petitioner is admitted to bail and salvation is on the council. Yes. Yes.
58 obliged my lords.
But under bail application was disposed of by your lordship on the because
yes.
I have also filed this charge sheet, my lord. And under the statements, my lordship, you can see that all the statements are similar. That is the common statements, my lord. And the person who wrote the FIR also, person you can see at page.
Yes.
Page 24. Page 24 is the sister of the deceased, my lord.
20?
Page 24, my lord.
24, my lord. Yes.
ମୋ ନାଁ ପଦ୍ମାବତୀ ମଲ୍ଲିକ ସଚେତନ ସର୍ ଆଜି ଆପଣଙ୍କ ନିକଟରେ ମୋର ଦିବାର ମୌଖିକ ବୟାନ କି ଆଜି 2/2/24 ମୋର ଭଉଣୀ ସୁଷମା ମଲ୍ଲିକ ଯୋଉ ମରିଯିବାର
Deepak Sahu.
ଦୀପକ ସାହୁ
Your petition is consisting of 18 pages only.
ମୋର ଭଉଣୀ
Additional affidavit.
ସୁଷମା ମଲ୍ଲିକ
Additional affidavit.
additional
Okay, yes.
since custodian since 3rd February, my lord. 3rd February.
February 24. Yes. Yes.
306 and 304 B, your order.
Yes.
Case. During the marriage ceremony, died.
How she died?
That due committed also that is
That's right. On that day, what had happened?
On that very the independent.
How she died? You tell me.
Due to your lordship, that is lordship. Due to may I read your report that was a point.
I understand it is hanging.
Yes,
but tell me, describe the circumstances. How?
I am reading it.
She herself did it, or these people have participated? I want to know.
Short date.
Not short. February. Yes.
Again, by the same appeal, the matter was dismissed for non-prosecution for the Hon'Ble High Court.
Yes.
There is no delay. Notice was issued.
Where is that order? Yes, no problem.
The order dated is.
When will you file this? When will you file this petition?
This petition was filed on 26/9/2022.
22. For the reasons stated in the application, the application is allowed, and the MACA number 1052 of 2006 is restored to its original file. list the matter before the appropriate bench, list the MACA before the appropriate assigned bench, subject to the approval of Honorable Chief Justice. Yes.
62.
Hon'Ble. Service.
Okay.
Complete. Despite service, non-APS for opposite party number 2, even for petitioner non-APS, in the interest of justice, urgent.
63.
Yes. Has he filed the application copy?
Nothing
Yeah.
is that, it's not required.
Huh?
He has not filed the order.
Right on. By the order dated 26/9/2024, the petitioner was directed to file the application. He had moved under section 311 CRPC, which was rejected by the impugn order. However, the said order has not yet been complied. Non-APS for the petitioner. It appears that petitioner is not interested to prosecute the present matter, accordingly dismissed. Yes.
65.
We cannot return back, my lord. Noting is required, my lord.
Service is not sufficient. Take first steps. Yes.
No, noting. Waiting, outing for 80, my lord. Some days, my lord. Outing for 80.
Everything. Everything the service. Yes. Yes.
66.
May I please, my lord? Now, in the noting, it states that the requisites has not been filed. I have already served the extra copy on 5/11/2000.
Requisites you have not filed.
But it has been filed, but in the noting, it shows that it's not been filed.
Requisite file. Let's say requisite file.
Beg your pardon, my lord. An extra copy has been filed. I'm beg your pardon.
That is how you waste your time.
Beg your pardon, madam.
The requisites pursuant to the order dated 28/10/2024 has not been filed. The petitioner is granted liberty to file requisites by tomorrow. If the requisites are not filed by tomorrow, the CRLMC stands dismissed without reference to the court.
68.
Yes.
Fixing, well, 12 or recording of evidence.
Yes. Report has come. Yes, my lord.
If your lordship laws
Here the few of the petitioners have absconded, immediately issued. You filed petition.
nobody had absconded, my lord.
That's the report. I have to believe with the order.
My
Report.
lord, I am merit of the case, your lordship.
Huh?
I am going to merit of this case, my lord.
But now, have you gone through the, my lord has a, have you gone through the, please go through the important address. Please go through the, pursuant to the order dated, order dated 8/11/2024, the learned special judge Vigilance Cuttack has submitted a report dated 13/11/2024. Mr. Mishra, learned counsel for the petitioner, may peruse the report and address the court on the next date of hearing. Please, after 1 week. After 1 week, just peruse and just.
Yes, problem.
Yes.
Well, Lordship, if they want to file any objection, let them file. Because on that day,
meanwhile, the counsel for the,
I mean, it will require, because for trial,
if counsel for the vigilance, if seeks to file the claim, he may do so. Yeah, file. If you don't want to file, it's all.
Yes.
Yes.
69.
This is 68 gone, huh?
Yes, sir.
You will prepare against, see, there are many accused persons.
Yes, my lord. Same case, my lord.
Yes.
Notice has been served up open number 2 and 3 minutes. Madam, previous order then.
Yes. Service sufficient.
Subject.
Yes. Despite service on the opposite party number 3, non-APS.
Next.
Release the matter after 2 years. Yes.
70.
May I please your my lord? I am praying for the quashing of the entire criminal proceeding, my lord. The informant is OP number 2 is alleging that her husband has married to me. In fact, the divorce has been taken place between the husband and the OP number 2. And allegation after divorce, yes, he married to. Yes. And allegation 492, 494, my lord. And the husband's case, my lord, is pleased to issue notice to the OP2, my lord. That is CLMC number 1404, my lord. That is listed, my lord. That husband's case, when it is listed, not listed yet, my lord. Only notice has been issued. Please list the present matter along with so and so 1404 of 2024. Yes, my lord. Up to 2 weeks. Notice has been issued, and stay in this case notice, in this case issue notice and list the matter along with so and so. Yes, and I stay the further question. What is your case? Let me understand. Yes, madam. Allegation ki after the declaration of nullity of marriage, the informant alleging ki I married to her husband, and she is alleging that divorce person has not been finalized because of some. That is for 494. Yes. All right. Maintenance was directed to be paid, and challenging that or the writ question that was a dismissed marriage. Therefore, she has no case marriage. But alleging ki I married to her husband, the then husband, the allegation 492, 494, 109 of IPC marriage.
In order to kind of glance at page 22. That is the 161 statement of the complaint. So what the erstwhile wife. But there she has claimed that she was tortured. As a result, she left the marital house and went to the father. Subsequently, a MAT case, matrimonial for divorce case.
No, you tell me the opposite party number 2 says that without divorcing, the marriage has taken place. What is the question of 498 against this ex-wife? Ex-wife of the.
That is very true. In fact,
it's only 494.
Yeah, Lord.
494. 498 will not be made out.
Please. May I be permitted to place few lines?
I'll just issue notice and you move application before trial court. Application before trial court. You immediately file process so that I will send it to mediation and finish it up. There is nothing. You have divorced your husband has already divorced. Are you happy with you? No. I am not happy with your husband also. No, my lord. She is telling I am the second wife for her husband. OP number 2's husband, my lord. Their divorce has been finalized, my lord. You are not married to me, my lord. She is telling married to me. I understand. Are you happy with your marriage or not? I am asking. Yes. You are happy with marriage? That's what I am saying. Second marriage, you have no option. You have no option.
There is no word in second one is the Hindu Marriage Act.
It's all right.
Yes.
All right. You are happy with the second marriage, then it's all right. No problem. Yes. Okay. A date may fix. That's it. Both the match. That case is not listed. Yes. Obliged.
71. Connected CLNC 4311.
Maybe tag together. 4371.
4311. By 20.
When that matter is coming up?
Next week.
Already
Judgment has been passed, my lord.
Yes.
Oh.
The marriage has been, so marriage decree has been passed, but only they filed for the quashing of the affair. That
Judgment. Touching on that judgment.
What is this case is about?
I can say after that, my lord, after the registration of that CP by the husband, 2 other cases have been registered by the wife, my lord. After 5 years. 2015 CP was filed. Thereafter 2020, 22, they have.
That is allowed. CP is allowed.
CP is allowed. That based on that judgment, I have said that.
Issue notice, let us see. Issue notice. At least
already notice
notice service provision.
It's a long very assist.
So what to do?
It is check for the we'll send it by lordship by special messenger.
Take her into 1 week after.
Yes, along with that.
Hello. Take
72.
May I please just.
Mr. Miller, though I have filed the case for a suspension of sentence, Miller, in fact, the problem has already been ready, Miller. Last of when you was to direct that comes to ready and the top of the list. Get ready to my since time not permitting for that one. There tomorrow, top of the list. There tomorrow, yes, finish. Top of the list. Let him address. Some appeal has to be done, Mallard. He argue or anybody else argue, Mallard. Appeals are not moving at all. He is ready to argue at Mallard. Let him argue.
Let him argue.
Okay. Yes.
Today.
Today. You know that you can't do. Therefore, he is saying that. He saw the watch, then he said,
You are actually reacting within 10 minutes, you are also can be aware of the fact.
No, no, at least 20-30 minutes.
Posted 7, you are working there.
7? Working is good idea. 7. Okay.
So that let them prepare the written note of argument.
Some ready. Yes.
74.
74. Yes. 74.
Lordship, in item 74, the revision has been filed by CVI. But one IA 501 by 23 is listed today, Your Lordship. By way of that IA, the opposite parties are praying for intervention of the wife of the second opposite party, Your Lordship. For the reason that the second opposite party has expired in the meantime.
No. This is your revision.
Yes, our revision is what? Against the order of acquittal, Your Lordship.
Against the order of acquittal?
Yes, Your Lordship.
And who wants to intervene?
The wife of the second opposite party, who was the second accused person who was acquitted, Your Lordship. Actually, the gratuity and pension has been withheld, Your Lordship, there. So that's why the wife is praying for including her into the current revision, Your Lordship. Where is it? 394.
Your Lordship, absolutely. I am for the intervention.
How 394 in a acquittal case is permissible?
Your Lordship.
You have been acquitted.
Your Lordship. But they filed a revision, Your Lordship.
Revision court.
While pendency of the revision.
If you would have been convicted and if appeal is pending or revision is pending, 394 is confined because the stigma is attached to you. You get out of the stigma. Now, since you have already been acquitted and the revision is pending against acquittal, 394 is not maintainable.
May I kindly read, Your Lordship, the section?
Why should you file?
Your Lordship, it is clearly mentioned, Your Lordship.
What?
All appeals.
Is the revision?
Your Lordship, revision and appeals are, Your Lordship.
Appeal pending against the conviction.
Your Lordship, that is provided, Your Lordship.
Yes.
In 2, in 1, it is written all appeals, Your Lordship.
This is a revision.
Your Lordship,
against acquittal.
Your Lordship, revision against acquittal, Your Lordship.
I have gone.
Treated at the same footing with.
You tell me one thing. Can this revision be allowed?
Your Lordship.
Against a dead person? Can there be a conviction?
No, Your Lordship.
He was honorably acquitted
Your
during his lifetime.
Your Lordship.
End of the matter.
Your Lordship.
End of the matter. The provision is automatically dismissed.
Your Lordship.
Nothing survives.
With respect to the second opposite party, Your Lordship. Only the second died, the first one is alive. Your Lordship.
Second one gone.
Yes, sir.
First one you prosecute.
Instructions that he has done, Your Lordship.
CBI has filed the present revision petition against the judgment dated 23/9/2008 passed by the Special Judicial Magistrate Bhubaneswar in
Absolutely, Your Lordship.
SPE number 3 of 2024, whereby the opposite party number 1 and 2,
Only two, Your Lordship.
opposite party number 1 and 2 have been acquitted. Acquitted. During the pendency of the revision petition, the opposite party number 2 has already expired. Therefore, in so far as the present revision petition is concerned, the opposite party number 2, the revision has become infractious. Accordingly, the same is disposed of as infractious. Insofar as the revision petition, opposite party number 2 be listed for hearing on Thursday. Yes. You are free now.
Your Lordship.
You go.
Your
I will dismiss it.
Lordship, just wanted to point out that opposite party number was convicted, Your Lordship. Only opposite party number.
I understand, sir.
Your Lordship,
The revision petition will survive insofar as opposite party number 1 is concerned. You are interested in 2. He has died.
Your Lordship, Your Lordship has passed the order that both of the opposite parties were acquitted. Opposite party number 1 was acquitted with respect to 120B only, Your Lordship. And the opposite party number 2 was acquitted with respect to 120B. Opposite party number 1 was convicted for 420 IPC, Your Lordship. 1, yes.
1 you argue, 2 is free.
Yes, Your Lordship. Your Lordship has the order that both of them were acquitted.
And therefore, as a sequel to that, the application moved by the the wife of opposite party number 2 under section 394 CRPC is also dismissed. Yes.
70
is also disposed of. Disposed of.
Much obliged, Your Lordship.
Yes.
75.
75. Yes.
Rejection of the distribution.
Sir?
Rejection of the distribution.
Okay.
In this case, there is a delay of 278.
Was there any stay?
No, we are coming for the first time. The delay is not done.
Now trial might have been over by now.
Well, it's a trap case, my lords, and my Lordman has also fairly stated that in his petition at
2003 discharge application was rejected.
Yes.
And thereafter the trial might have been commenced and many things might have happened.
I'll take his instruction, but so.
Trial has not been commenced.
But so far, if that is there, then so far the case is concerned, Your Lordship produced 2 lines of petition. The petition has fairly stated, this is a case of trap lots. In page 11 is that mere statements of the complainant and the accompanying witness are not sufficient to prove beyond reasonable doubt that there was demand of illegal gratification. So he admits fairly that so far the
I can't appreciate the
and in fact he has on 3 grounds. One, certain material documents cannot be seized, and certain independent witnesses available could not be examined. And another ground he has taken with regard to the entire pension amount could not be recovered. But with regard to the top case, indicating there is grave suspicion with regards to compensation amount.
Yes.
Statements, complainant, shadow witness, good enough.
Yes. Yes, sir.
Yeah, this comes from over.
List it up, sir. January. January, yeah? Hearing matters. The board adjusted, 76, yes. Any urgent mention?
This kind permission. Extremely sorry, I was just in a part matter that 59 is a review, which is specially assigned to the Lordship. I only pray anything Lordship may decide positive after that.
The judgment was long wait.
It's necessary because that man is deprived of the property. If your Lordship decides no, he doesn't deserve anything in the review, that also, my lord, I only humbly pray your Lordship may kindly take up from the list tomorrow, my lord. I was very much here, but the Pathar matter went on, my lord. I just tried to rush in, but
I am serious about this.
Profit mentioned, my lord.
No, do you have a case?
I feel I have a case. I'll just assist your Lordship.
Friday. Okay.
I'm grateful, my lord. I'm grateful.
101, my lord. It is an urgent matter as to crop of the prisoners and
tomorrow it will be. Or the matter which I would not take. Next week we will adjust and finish.
the interim order and the restraint from.
Under one?
Yes.
Now what is the interim order?
In the interim order, both the petitioner and the opposite party, he has been restrained from entering into the property. But my lord, the harvesting period has been started. And the crops are getting ruined, my lord, because no proper this is there and they are not able to inspect it properly. And my lord, like the last order was my lord, September.
Cutting of crop. Okay. We should score the way it's urgent. Yes. Because there is an invasion kind of order. The crop cutting is stop and all everything in it. I see he has filed the criminal MC. What kind of this interim order? This has to be very. See, it says that they will not enter into the crop cutting industry and all these things. Whatever the criminal case is, either it to court or it is to go on. But you can't restrict someone to get into the crop field and all. And they are the agriculturists. How can you stop it? Anyway, I saw the interim order, so I released it. Tuesday.
Item number 102. Item number 102, on 9th, I have informed Appellants Council. It will be taken up on 9th.
9th. Yes, 77. Which one?
37, item number 37, that is that.
Yes.
And that arising out of the same PS case, this 77.
77, I know.
So the whole point about they posted to 21 for framing of charge. So I feel that you will also decide before that is over the interim order may be extended. In 77, or your lordship may give me opportunity for extension because
21st,
the order I'll want the also be here for this service.
2012 मसीह petition different contest 77 number of petitions are high there. Discharge petition rejected 2023.
77. Oh, 1 minute.
So day after tomorrow charge
pending since 2012. No entry order. Today overnight you want entry order.
No, overnight I don't want. Before hearing me, if the lordship will hear the opposite party, this usually happens.
No, I can see the number.
Hear the fact in this.
I will hear it, but next week.
What is that? Your lordship hear that allow or reject it? I don't mind.
But for hearing also I need to have some time. And particularly hearing you. You argue at length.
Different animal than
No, you argue at length. And you are so super brilliant what to do.
I just want to say that I mean clearly what I have learned in last 45 years.
So that is the reason I am saying you argue at length.
No, not argue, but the whole point is the interim order was I made it.
2012 nothing happened today overnight what will happen?
That is what if your lordship will hear, then only I can say.
I will hear
if your lordship can see.
Tomorrow. Tomorrow let it be here. Or let it hear first case.
First case as well.
No, not first case. Then the entire board will stop.
37
along with
37 interim
I will hear you tomorrow. Get ready.
37 your lordship kept it for judgment reserve.
I will not pass the order. I will hear this and pass the order.
Tomorrow. Okay. Yes. Tomorrow at 2 o'clock you come so that I can.
Along with 1728 of 2000.
1728 कर देता हूँ. Yes.
1728.
1728. If connected matter once I hear, if you can dispose of 2-3 matters, why not? Yes.
The whole point is there is no time and there as your lordship put me into a different category of animal. Now I don't want to say anything. I will say.
You should be happy that I put it in a very higher pedestal.
But your lordship has kept it whether it is a human being in higher pedestal or animal.
No.
That have to be.
You are always in a higher pedestal, looking into your experience. Yes.
Help it. Yeah, sometimes it has become like that. Cases have been done.
What to do? See the board. I know the board is so heavy. Yes.
This was first time.
Which one?
Item 18, you understood that already. Item 18, my learned is saying for item 18. Your lordship item 18, after your lordship clearly passed over. Second,
pass over but I had issues for
18th कौन है? Dispose of, I might have given something. I don't give.
No, this is
No, I'll just take it up. Okay, 18 note करी मत कोई बोटिंग है. I'll not pass adverse order. Don't worry. Yes. I'll make sure. Sir, I'll not pass. Sir, let me see what. First of all, you don't come in second call. Second, you don't come. You could see better internet, but you don't come to the court. Next week, I'll see. देखिए ना, before the scheme is decided.
The 26 government is allowed 2009 complaint. Once it is rejected, once see that fact that again there another application.
You are the informant.
So 2009 complaint.
And it will be listed next week. All the matter which I couldn't take up, I'll be check it next week. Yes. The seniors are there if they want to mention. Sir.
157. Matter one was heard at length, and my lord had directed that vigilance appeal, where that regarding the from 5% the disproportionate and were 38%. And
who was appearing further the same? You ready?
He has taken time on the purpose of.
I have already received the up-to-date CD.
Then let it be. Then I'll hear it. If I get tomorrow or after. I will not give date because I don't know. If date is given, it may not reach.
No.
Yesterday I was searching Vigilance Council, nobody was there.
Yes, I was in fact for that matter also.
3:30 I was free. I was thinking that if somebody is there, I can hear some appeal. Nobody was there.
We were there, my lord. I was there till 2 o'clock, 3:30.
Let us hope tomorrow. I think I will be finishing my board little early.
My lord had fixed it earlier also at 3 o'clock.
Let it be there. I'll just check it. Take it up. Yes.
Well, it's item 92.
97.
Next week, also. Senior Mr. Pradhan is there. One week. Yeah. 85. Okay. Is it very urgent? We'll see next week. I'll just take it. All the matter which I couldn't take up will come up next week. Adjust and give.
Item 92, I shall be considering an application within CRLMC which I am challenging the order issuing process against me. If it can come up on the 7th, I shall prefer an application. The departmental proceedings, they are not concluding it, taking that these proceedings are pending. A small clarification application I shall be preparing.
What you are challenging what?
The order issuing process against me, Now, I was not named in the FIR. I am a police officer, I was not named in the FIR. The first
process you should go and appear. What is the big deal?
Your lordships have protected me in the meanwhile.
You are a police officer. You are acquainted with the courts. You don't feel out of place. You go and
writing a departmental proceedings pending, Your lordships can keep it on 7th. I will prefer
departmental proceeding act in a different parlance also. Nothing to do with this. Why do you worry? It is a process only. Let us see. I'll take it up. Next week anytime. Yes, yes, sir.
Pardon my lord, item 132.
84. काली को तो कहीं अब नहीं किंतु आते हाँ? Unsuccessful mediation. It need to be heard. Okay.
Pardon my lord.
97. Yes.
Next बुधवार है
97.
97.
next बुधवार है Friday.
What is this case? What is this?
109 wife.
109 wife.
That is
same story.
The wife, principal accused are already been died. They were all the
Assets.
the amount free. Let's say the wife of the principal accused cannot be day to day.
Just today only I pass an order.
Deep interest are yours. सब जगह से demand करछन. सब क्वेश्चन मोर सोर्सेस ऑफ इनकम अछि टेलरिंग फेलिंग सब दिन इनकम टैक्स रिटर्न देते.
No, income tax.
You not covered by your loss.
109
Clearly attractive.
we'll see.
Pardon my
Yes.
lord.
Today only the same thing Mr. Rai argued. I passed the order. If you have a separate defense, then you have to prove it by fishing trial. As simple as that. Yes.
Next बुधवार
Permit to allow.
Next, anything mentioning? Okay.